All right, the Courts of Justice Committee will come to order, and the clerk will we'll open the roll.
You have a quorum, Mr. Chair.
All right. We've got another heavy docket today. We're going to try and move through it as efficiently as possible. I would note that we have 11 bills that are essentially identical to bills that this exact same panel addressed last year. And we're going to abbreviate consideration of those bills, not because I don't want to give them a fair hearing, but we've already heard them. And unless there is a compelling need to extend the hearing on any of those, we're going to try to move through these as efficiently and quickly as is reasonable. We've got some folks signed up. Senator Black, you're first up. Senate Bill 1024.
Thank you, Mr. Chairman.
And Senator Black, this is a bill that also was on the list of bills that we considered last year. It removes the prohibition on carrying firearms in church. It basically provides that church gets to decide, like most other businesses in Virginia or property owners, whether it's going to permit people who come into its premises to carry a firearm or not. Is that right?
Yes, sir. And it's a bit of an anomaly that there's a carve-out for churches from other properties. I'm not sure who asked for it or where it came from originally, but that was probably before any of our time. But with the repeal of that particular prohibition of concealed firearms in churches, the concealed carry rules will apply just as they do anywhere else. Each church controls its own property. They can prohibit
Senator Black, I think
if they want.
I think we understand those who are opposed to it are probably still opposed to it. Those who support it are probably still supportive of it. Unless you feel compelled.
I will keep it brief, but I think one thing that has changed.
It reported last year.
Okay, but I'll be brief. One thing that happened is after the shootings in South Carolina, they killed quite a few people down there. Something happened, and I was not aware of it until recently, but churches have instituted armed guards inside, and I'm not talking about, hired people, but I'm talking about concealed permit holders. It is all over the place. It really is. And I share that with you because I think it was new to me. I didn't realize it, but I started hearing and heard more and more about it. So we do have them there, and what this does, honestly, is just recognize the existing situation.
Thank you, Senator. Anybody wish to register their support for this bill? And I'm talking register your support, okay?
VCDL, we support the bill.
Thank you.
Support.
Anybody else? All right, anybody wish to register their opposition to the bill? All right. Anybody feel compelled to speak? All right, Senator Stewart.
Mr. Chairman, move to report the bill.
All right, it's been moved and seconded the bill be reported. I'm sorry, let's strike the roll. I'm sorry. Is there somebody who felt compelled to speak that?
These faith leaders had come down, yes, last weekend, this morning.
All right, we're gonna hear you for 3 minutes.
Good morning.
Good morning.
I'm Gary Creditor, Rabbi Emeritus of Temple Bethel here in Richmond, Virginia, and board member of the Virginia Interfaith Center for Public Policy. Tree of Life Congregation in Pittsburgh is my denomination. Its former rabbis were my classmates. I am opposed to this bill. Houses of worship are houses of peace, and security can be secured outside by the houses as each they decide to do. I would bring to the attention of the committee that in Solomon's temple, according to the book of 1 Kings, that no manner of hammer or iron was to be used, for these were to be places of peace and not with implements of war. This bill is not the way. In the name of the martyrs of the Tree of Life congregation, I ask you to oppose this bill.
Thank you for being here. Yes, sir.
Yes, sir. Good morning. I'm a United Methodist minister. My name is Rodney Hunter. I oppose this bill as a veteran. I'm trained with firearms. I still wouldn't feel comfortable with the firearm in church. I think it would create an atmosphere of fear more than worship. And Jesus said that if the householder had known what time the thief was coming into the house, he would have prevented him from coming. So I just feel like we just aren't always equipped and prepared for such situations, and I think would be more harmful than helpful to have guns in worship.
Thank you for being here.
I'm Reverend Lauren Ramsor. I'm a Presbyterian pastor. I oppose this bill. My concern is particularly for the children in worship. I'm a pastor for children and families, and I think this creates a real problem for children who are going to be moving around in worship and a firearm could go off accidentally. We know many children are killed by firearms by accident, and I want my house of worship to be a place of safety and refuge for all people, especially children.
Thank you.
I'm Pat Shipley. I'm a retired United Methodist pastor, last serving at Centenary, downtown Richmond. I oppose this bill because the current law allows churches to provide for the safety of their places of worship in ways that are theologically and practically consistent with their creation of a sacred space for worship. And I believe allowing more weapons would violate that sacred space.
Thank you.
Hi, United Methodist pastor Todd Guess. I serve two congregations. I've just been newly appointed to Mount Zion in Strasburg, Virginia, and also Mount Zion in Woodstock, Virginia, two African-American congregations. The current language, as in that this bill will change, will not bring protection to a minority group. It'll actually bring access for people who want to do harm into the middle of that congregation and cause harm, because they will be able to take those guns into that worship. Thank you.
Thank you for being here.
Warren Hoddle, Chairman, members of the committee. I want to remind the committee that last Wednesday we celebrated this Assembly's passing the Virginia Statute for Religious Freedom. For 233 years, the Commonwealth has honored a tradition keeping the state out of affairs of churches. I hope this committee will not further erode that tradition.
Thank you for being here. Time is up. If you would want to step up, introduce yourself, and say what organization you're affiliated with and register your opposition, that's fine.
Linda Higgins. I'm here both as a representative of the United Church of Christ and my own congregation, St. John's United Church of Christ here in Richmond, and we oppose this.
Thank you.
Felicia Preissner with the Virginia Catholic Conference, and we also oppose this bill. Thank you.
Thank you.
Good morning. Amanda Silcox with the Virginia Interfaith Center for Public Policy. I'm a Lutheran, and I oppose this bill.
Thank you for being here. All right.
Mr. Chairman.
There's a motion on the floor to report the bill, which has been seconded. Roll is open. Hey. Oh, I'm sorry.
Ayes 7, noes 5.
All right, the bill reports. Thank you, Senator Black. Next up, we have Senator DeStef, Senator Eben.
Good morning,
Good
Mr.
morning.
Chair. How are you?
Senator Eben has Senate Bill 1007.
Okay.
I'm sorry. You want to do 997 first?
Yeah, let me just see which one is which. 997 is the marijuana decriminalization. You've seen...
And Senator Eben, same admonition that I gave to Senator Black, not because I want to cut off discussion, but this is essentially identical to
Yeah.
what we took up last year.
There's an amendment in the nature of a substitute, small changes, but I'm going to try and go quickly
All right.
with this, if you'd
Is
like
there a
me to
motion to
explain
adopt a
it.
substitute? It's been moved and seconded. All in favor signify by saying aye. Aye. All opposed, substitutes before us.
This bill is just a little bit different in that it establishes the crime of public consumption on the street or wherever, and consumption while operating a motor vehicle. Public consumption results in a Class 3 misdemeanor with a fine up to $500. Consumption while operating a motor vehicle would be a misdemeanor punishable by up to 30 days in jail and $500 fine. Right now, it's the same. I believe it's the same, and we have a witness who can clarify, as just possession. Now, you've heard it before about the disparate penalties, about the support from NAACP, racial disparity, and so forth. So the policy question is whether or not we'd like to treat people who in large number who are already consuming marijuana through society, in our society, whether or not we want them to lose security clearances, whether or not we want them to potentially lose student financial aid, have employment issues for the rest of their lives. And I do have a witness, if there are questions. I don't know where she went. Jen Michelle Padini from the from Normal is here as well.
I don't know.
And if there are questions, we can clarify.
All right, thank you. Anybody have any questions? Senator Stewart.
Senator Evan, I was trying to read the substitute quickly, and on line 428, it says unlawful for any person to smoke, consume, et cetera, marijuana while operating a motor vehicle, et cetera. And it makes it a fine, 30
Yeah,
days in jail.
it's a
Does this
fine.
supersede the DUI statute?
I
how
think
does it
that's
jive with the
probably a better
DUI?
question for counsel, because I'm not as familiar with.
Charles, Steve?
Mr. Chairman, I don't see why it would.
Well, Mr. Chairman,
Senator Stewart.
at a minimum, it conflicts with it. So you're going to punish now people, so is this an additional offense to DUI?
Well,
You can punish them for both?
Let me see on 428.
Mr. Chair,
Hang on.
it's an additional offense if you drink while driving.
What?
You want to phone a friend? Maybe
I'd
Senator
like to phone a
Deeds has
friend,
an
Senator
answer.
Deeds.
Mr. Chair, I was just pointing out that.
Your
there's a-
microphone.
I apologize. I was just pointing out that there's already an additional offense if you're drinking while driving from a DUI. If you have an open container and driving and you're drinking, you've got that separate offense from DUI, and this is a similar offense.
All right, so, Mr. Chairman.
Senator Stewart.
Senator Eben, was it your intention to charge these folks who already would be prosecuted for DUI or DUID with
yeah.
another offense which could land them in jail for 30 days and a fine?
Well, the reason I wanted to do that was because I knew you would pass it when we do that. And I thought that, I think that's.
Senator
what-
Eben, you don't know me as well as you think, because
Oh, no, I mean-
I'm not a guy who believes in piling up charges on defendants.
Yeah, I meant your colleagues. I would be fine if the committee doesn't want to include that, but I thought in the past, I've heard some resistance to that. The other piece is because it's just a fine, I thought the committee would want something a little bit more serious. And we don't want to encourage. What I'm trying to do is say if you possess small amounts, you're using in your home, that it would be decriminalized. We don't want people necessarily to smoke on the street, and we want to discourage them from smoking in their automobile. That's my suggestion. You'll notice it says consumption and not possession in the motor vehicle. Because obviously if you're possessing it and you go anywhere, you're probably in your motor vehicle. But consuming, whether the car is all smoky or you are have the DUI, would be a slightly different matter.
All right. So any other questions? You okay, Steve?
To finish up answering that question, the DUI statute prohibits operating a motor vehicle while under the influence. This does not. Simply smoking Yeah, per se, that's right.
Mr. Chairman.
Senator Stewart.
As Mr. Benjamin points out, it's a per se violation. And my concern is that you now can get prosecuted for both offenses, and you've got 2 Class 1 misdemeanors.
Double jeopardy. Are they? Drive under the influence. Here you actually have to have the marijuana. Yeah. That may be a risk. We're debating, Mr. Chairman, whether double jeopardy would prohibit 2 prosecutions, but I think Charles is correct that there are different elements, and so you could be convicted of both. That's
Right.
correct. There are other consequences that would arise from this as well, but.
All right, well, we've got a larger policy issue, and if that remains a concern, maybe we can address that, but let's see if we can hear from folks who feel compelled to register their support and opposition with the understanding we've heard this issue.
Yes.
Same panel, same
Yeah.
issue. We've heard it before.
I brought one witness with a lot of experience. Perhaps the others could just register their opinion.
All right, thank you. Step right up.
Hi, good morning, Mr. Chair, committee members. Jen Michelle Padini, representing Virginia Normal. We support the bill and thank Senator Abbott for his continuing of the conversation regarding decriminalization. I'm happy to answer any questions.
Thank you. All right, anybody in opposition? Yes, sir.
Oh, I'm sorry. Lieutenant Gilbert with the Virginia Sheriff's Association. We oppose the bill.
All right, thank you. Anybody else? All right, the bill is Mike. Association of Commonwealth Attorneys have a position on the bill?
Mr. Chairman, Mike Doucette, Executive Director of the Virginia Association of Commonwealth Attorneys. Our association did not take a position on this bill. We had a meeting last year. Half of our association wanted to continue the laws as they are. The other half of the association wanted to take the jail offense out of it and just make it a finable offense. We actually do have a member who wants to make it legal, but we do not have a consensus, and we operate by consensus. That being said, we're open to continuing dialogue on this as far as all the ramifications, the DUID, the edibles, the children, all those. We're open to a dialogue on that, but we do not have a position on this bill this year.
All right, thank you.
I have a question, Mike.
Senator Edwards.
Doesn't this kind of, you already, it's an offense to, under the influence of marijuana to drive, right, if you can prove it? If you can prove
Mr.
it.
Chairman, Senator Edwards, that is the crux of the matter, is proving it, because unlike alcohol, there is no finite objective measure as far as the THC in the blood.
But this one adds to criminalizing marijuana in the sense that if you can show that a person otherwise ingests marijuana in a public place, it's a Class 3 misdemeanor, correct? And under this, the way I read it. And secondly, if you are while driving or operating, is per se. You can't smoke, consume, or otherwise ingest while driving.
Mr. Chairman, Senator Edwards, there are parts of this bill we like, but as the general theme, we have not taken a position, and we operate by consensus.
I understand that, but I'm just trying to make sure everybody understands what this. You can
All right.
argue that it makes it tougher on people who smoke marijuana.
And Mr. Chairman, Senator Edwards, again, as Senator Stewart put it out, we may not want to be adding on these particular additional offenses. We, as prosecutors, are always looking to put people in jail. And I think that...
No, you're not. You're trying to maintain the public safety.
Absolutely.
Okay?
Absolutely. And sometimes that includes putting people in jail, and sometimes it doesn't.
Exactly.
All right, thank you. The administration?
Yes, Mr. Chairman, members of the committee, Nikki Zamosny, Assistant Secretary of Public Safety and Homeland Security. We support the bill. The reason that we included the provision about smoking in the car is we wanted to ensure there were some additional penalties if somebody, was taking that action in their vehicle while operating it. So we appreciate your consideration. Thank you.
Thank you. All right, the bill's before us. There's motion or report properly seconded. Let's open the roll.
Ayes 5, noes 9. Okay, we'll
All right. Thank you,
We'll be
Senator
happy to
Eben.
be back next year on that.
I have every confidence that you will.
Okay, let me talk to you about the two bills that I know you're going to pass. One is Senate Bill 1230.
Mr.
And
Chairman?
we've got an amendment for
Mr.
that one
Chairman?
also, a substitute.
Senator McDougal.
But Senator Evan, before you move off of this has been alcohol, marijuana, opioids, impact on the criminal justice system has been something that's been very concerning for many of us. And I know that the Deeds Commission heard over the interim from a expert at MCV about impacts of all these different substances on the brain and thus reaction. So I asked the chairman and have invited that same doctor to come in and give a presentation to us on Wednesday during courts committee about how all these things impact, because it does impact our ability to make policy. And Senator Deeds, you remember, and I thought that presentation was very important for this group since we tend to make most of the decisions around it.
Yeah, we're going to do that this Wednesday, and I would hope that everybody would attend, all the members would attend. I think it will help inform judgment on this and other issues this year and in the future. So thank you, Senator McDougal, for making those arrangements.
Just to follow up
Senator
on that,
Eben.
sir. I think Senator McDougal is a member of the Crime Commission. Oh, I'm sorry, well, anyway, there's a few of you on the Crime Commission. Perhaps you are, sir.
Senator Howell, I am.
Okay,
Senator Norman.
I know you remember that comprehensive study done by Crime Commission staff, and it was pretty thorough. But one thing to keep in mind, whether it's the Deeds Commission, your witness on Wednesday and so forth, is that the disparate enforcement around the state, where some Commonwealth's attorneys are charging or are saying there won't be any jail time and others are, and some are not even charging, is kind of an indicator of unfairness, although I agree with those who are not, and the racial penalty, that it is disparate because this is changing. I just wanted to throw that forward. The next bill was 1230.
All right.
And that is also an amendment in the nature of a substitute.
All right, is there a motion to adopt the substitute? It's been moved and seconded. All in favor signify by saying aye. Aye. All opposed. The substitute's before us.
Okay, so what this does is it expands the domestic violence definitions. Less than the original bill that was to come in was in terms of how it would be enforced. What we're doing now is amending it to include extended family, not just those that live together in the household, and very, very importantly, to add a dating relationship into the statute. And to see that it wasn't too broad for enforcement, what we did is we followed the example of some other states and said it would only be, this would only apply to assault and battery, stalking, and bail admission for strangulation. And it's very narrow. The current statute does not include dating relationships, where we know that it really is a lot of people in dating. We don't want people who are dating or ending dating to be stalked, abused, and so forth. We know that they are more likely to be abused by an intimate partner, a young woman, 3 times national average. High school kids, we've got 1.5 million reports of physical abuse every year. And college students, half the women in college report experiencing violent behavior abuse. And I would just finish by saying, and I've got a lot more for your questions, that right now, dating relationships are part of the code of Alabama, Colorado, Iowa, Kansas, Michigan, Mississippi, Nebraska, North Dakota, South Dakota, Vermont, Wyoming. And even the extended family piece with the dating relationship is a total of 24 states. And 36 include, so that's 36 in total that include dating relationship, and there's extended family in a number of states as well.
Adam, I think that all of us agree with your goal and would like to make sure that people are protected. We talked about this in our courts working group. Steve, you want to share some of your thoughts and concerns about the approach that Senator Eben is endeavoring to take?
Mr. Chairman, The challenge of the motivation, I think everyone understands that the motivation is pure behind the bill. The difficulty is execution. And the challenge of defining what constitutes a dating relationship is a challenge that this committee is familiar with. It came up probably many years ago when Senator Watkins tried to do the same thing with legislation that would permit protective orders for those in a dating relationship who were subject to assaults or threats. And the problem that the committee grasped then is the same problem presented by this bill. It is impossible to define satisfactorily what constitutes a dating relationship. One person may feel that they are in a dating relationship, while the other one would be surprised to discover that. You can't define what constitutes frequent associations. People will differ on that. You can't define at what point an association becomes intimate. People in the same relationship will differ on that. And especially challenging is determining whether any relationship is primarily characterized by an expectation of affection. Again, the same people in the same relationship may have vastly different opinions as to what that relationship is all about.
Exactly.
And that's why it's simply impossible to make that part of a criminal statute. There will always be ambiguity. The other problem is the expanded definition of family member. We have definitions of family member, of immediate family throughout the code. Each of those definitions requires that they be individuals who live in the same household. Here you're extending it not only to people who are not related by blood. One example is an ex-spouse. The bill doesn't require that they live in the same household. And it becomes almost unworkable. Again, I know that the patron's intent is pure and driven by good intentions, but the difficulty is achieving what the bill seeks to do.
Mr. Chairman, at the risk of disagreeing with Mr. Benjamin, which I'm going to do now, I'm not an attorney, but I think if you wanted to take out the family, I can understand if that's your decision. But I think a judge is capable of deciding what a association primarily characterized by an expectation of affection or sexual involvement independent of financial consideration. We know this is the definition that is used word for word in Alabama, Michigan, Nebraska, Nevada, and California. We know it's also, the concept is in 14 other states. And we also know, as I gave you some of the numbers, of 1.5 million nationally of those in relationships in college. I'm sorry, those are high school. And 50% of women in college reported experience violent behavior or abuse from the Knowledge Network's poll of college dating and abuse. Further, I would say that we know that in Martinsville in 2017, a woman was killed by her non-living boyfriend. And when the officers were called before for domestic abuse, they couldn't offer her or didn't offer her the services that are available to the victim in this sort of case.
Senator McDougal.
Mr. Chairman,
question.
I guess I'm a little bit at a loss. Right now, you have the ability, anybody has the ability, regardless of the definition of the relationship, neighbor, friend, stranger, whatever, to go and get a protective order in district court. Most jurisdictions that I'm aware of have established some cross-jurisdictional designation between the district court and the juvenile and domestic relations district court, and most of them are actually, not all, but many are in the same courthouses, the district court and the juvenile and domestic relations district court. So what I'm having a hard time understanding is if anybody can go get a protective order, regardless of what their relationship is with the other person, why would you want to put in a catch for somebody to be in the wrong place, filing in the wrong court? Seems like we've already covered that. Isn't that right, Mr. Benjamin?
Yes, that's right. And that's why the protective order statute is what it is now. We because we could not define dating relationship, the General Assembly expanded the protective order statute to cover everybody, so that if you were at a threat of abuse or harm, anybody could go get a protective order.
All right, let's hear real briefly from people who support the bill. You'll
Okay.
get the last word.
Okay.
Anybody in support of the bill wish to be heard?
Good morning, Mr. Chair, members of the committee. I'm Sarah Taylor with the City of Alexandria. We brought this to Senator Ubben after a work group between our law enforcement and our domestic violence folks, and we asked them to come up with some practical, actionable ways that they can make each of their jobs easier. And we didn't want them to reinvent the wheel. We wanted them to look at what was being done in other states. And I think, Senator McDougal, specifically to your point, by putting this definition in statute, it takes the onus off of a victim to be the one who has to go and get the protective order. It leaves less time for them to have concerns about going through the process. It makes the process.
Senator Stewart.
Could you explain that to me? Why does it take the onus off of the victim to get a protective order? They're the ones who always have to get a protective order.
My understanding, and I am neither a lawyer nor a law enforcement officer, but my understanding is that because it would allow for them to fall under mandatory arrest and would be handled in the same manner, that in domestic violence cases, the burden of getting the warrant is on the officer, whereas if you go to get your own protective order, the burden is then on you. And again, I'm neither a domestic violence worker nor a law enforcement officer, but that is.
I don't think this bill
Senator
would
Stewart.
change any of the processes in getting a protective order. from
Well,
the
again,
way it is now.
Mr. Chair, when we looked for solutions that existed elsewhere, and the fact that this definition or a version of this definition exists in a number of places, we thought that it was a reasonable definition to propose for expanding not only making law enforcement's job easier, but making domestic violence folks' jobs easier in dealing with victims.
All right, thank you very much. Anybody else wish to speak in support of this bill?
Mr. Chair.
Anybody, you have a question of
I had a question,
Alexandria?
and maybe it's I was going to ask the young lady, but I guess my question is, if I look at this definition of family or household member, it talks about any individual who is in or has been in a dating relationship with the person. If I look at dating relationship, it says, means frequent and intimate associations primarily characterized by an expectation of affection or sexual involvement.
Sir
or
Peterson,
sexual
I
involvement.
think you missed the soliloquy by counsel on that very issue.
It just seems like it would cover pretty much everybody.
All right.
It may very well.
Okay.
Let's hear from those who wish to register real briefly their opposition to this bill or concerns about
Morning,
this bill.
Mr. Chairman. Richard Garrett for the Virginia Bar Association, the Virginia Family Law Coalition. We're going to adopt Mr. Benjamin's soliloquy. He hit it on the head. The only other issue that we brought up in our meetings was there's no time limit. It says has been in a dating relationship. Somebody you dated in high school could show up and now ask that you get a domestic violence charge against you at a reunion. So we're definitely opposed to this bill.
Point well made. All right, next.
Mr. Chairman, I'm Daniel Rutherford, members of the committee, Commonwealth Attorney for Nelson County. I'm here on behalf of the Virginia Association of Commonwealth Attorneys. We also oppose this bill.
All right, thank you very much. Next, Adam, real briefly.
Just
Senator
briefly,
Abbott.
just briefly to wrap up, if the committee wanted to change it just to say an individual who's in or has been in a dating relationship, we all know what a dating relationship is. It's one-on-one meetings or dates. And I think a judge can figure that out. If you're going to the movies together, you're getting an ice cream soda together, you're having sex.
Mr. Chair.
People know that's dating.
Senator Norman.
Mr. Chairman, I rely.
Mr. Chair.
Senator Norman.
Mr. Chairman, I rely upon counsel. I move to PBI.
All right, there's a motion to pass the bill by indefinitely. Is there a second? Second. It's been moved and seconded. Senator Deeds, did you have something that you felt compelled to say that I
wanted to
cut you off?
I wanted to point out to Senator Eben is if you're 61 years old and you took somebody for ice cream when you were 15, you might have been involved in a dating relationship 45 years ago. That to me is the crux of the problem with this bill.
All right. Motion to pass bill by indefinitely. I think we all agree with Senator Evans' motives and would like to advance those, but vote is open.
Ayes 15, no zero.
That bill is passed by indefinitely, gently.
Thank you. Thank you, Mr. Chairman and members of the committee.
Next up.
Okay. I have a friend on this one who's sitting on the panel, I hope, which is Senator Normant. And I don't know if council has a line amendment.
What number?
Oh, I'm sorry, this is 1231.
All right.
About the video review, do you have that?
Is there a substitute?
It's
Or
not a
amendment?
full
No.
substitute. What we intended to do was to take it back to, instead of having them come up for, let me just explain the bill, and then I can explain the line amendment that we intended to have in today. We, right now, an unrestorably capital murder defendant, who those who don't remember is someone who's not able to participate in their own defense and doesn't even really comprehend the crime they were in. Now, right now, they have to come up to the local court every, I believe it's 6 months, for a review that they are incompetent, in fact. And there's quite a process to that. A whole caravan of law enforcement. Just if they're unrestorably incompetent, unless they've been restored, it's the same thing. And unrestorably means you're not expected to be. So what I intended to do was walk back all of this part about the frequency of the reviews and so forth, to allow video participation with the court. And the other piece that I think is important is to say that no unrestorably, on line 78, incompetent defendant charged with capital murder shall be released except pursuant to a court order. This comes from one case in Alexandria, one case, I believe it was Williamsburg, and if you're considered unrestorably incompetent, it means that you're not competent to participate in your defense. If we continue to review them, but it's done by video, we save the court, we save the Commonwealth, we save sheriffs.
Adam, I think that there is, unless I'm going to be surprised, I think there is a pretty broad consensus that this represents good policy. Anybody, I know that we talked about this in our work group. Is there anybody here in opposition to this bill?
Move to report.
All right, it's been
Don't
moved.
state anymore.
Do you have an amendment?
Only if Senator Normant feels that we should. Okay.
All right, there's a motion properly seconded to report this bill.
Great.
Are you unrestorably incompetent?
Ayes 14, no zero, one abstention.
I can't thank the committee enough for raising my batting average today. Now,
That's what
the
we're all
last
about.
bill,
We want everybody to feel good about themselves in here.
I hope you feel good, I feel good, and I hope that the courts around the state will feel good. The last bill you've heard before, it has to do with banning the ban on, repealing the ban on same-sex marriage in line with the Supreme Court. Now, we know that it's that it's obsolete, and that same-gender marriage has been recognized since 2014 in Virginia. It's now 2019. We know after Loving versus Virginia that we repealed our law just one year after Loving versus Virginia. The Code of Virginia has to accurately reflect the law. Both Senator Edwards, Senator McDougal remember that the Crime Commission recommended unanimously that that the commission ought to support statutory repeal. And the Attorney General issued an opinion that the holdings of the Fourth Circuit and the Supreme Court should be those reflected in the code. This is a policy matter, not a social matter, as to whether or not we want to reflect the law.
Mr. Chairman?
I'm sorry, Senator Edwards.
I'd first like to have that my bill 1306 be rolled into Senator Evans' bill, and I so move.
I'm sorry. You want 1306
Yeah,
rolled
1306.
into Senate Bill 1007 with Senator Eben and Edwards listed as chief co-patrons. All in favor signify by saying aye.
Aye.
All opposed. That motion
And
is
Mr. Chairman-
adopted.
Mr. Chairman, I'd also like to say a word or two about this. The Code Commission did consider this. The Attorney General issued an opinion saying their law, the statutory law, was no longer appropriate and as being, what's the word, outmoded, and recommended, obsolete's the word, and recommended that it be repealed. And based on the Attorney General's opinion, the Code Commission recommended it be repealed as well. So
You want to finish your comments with the motion?
Yeah, so I moved, well, I support Senator Evans' bill and move that it be reported.
It's been moved and seconded that the bill be reported. Bill is before us. The roll will open.
Ayes 7, noes 8.
Well,
Bill's
I thank
report.
the committee for helping us do better this year, and we'll be back next year until it passes. Thank you.
Thank you.
Thank you, sir.
All right. Next, we have Senator DeStaff.
Morning, Mr. Chair, members of the committee. I'd like to
Senate Bill
first.
1151.
Okay, let's start with that. Mr. Chair, if it's okay, I'm going to ask the pages if they'll step out for a minute on this one.
Sure.
Thank you. And Mr. Chairman, on 1151, the element of ruse in sexual battery covers incidents involving doctors, chiropractors, massage therapists. Due to the nature of the experiences with these professions, there's rarely FTI present, as the offender uses the ruse of professionalism to earn the trust of the victim. Today, under force, threat, or intimidation, if there's object penetration or penetration, then it's a felony. With a professional, hardly ever is FTI present. So when these professions are committing an offense that would be commonly fall under the code of OSP, but due to the nature of the experience, FTI, force, threat, intimidation not present, it falls under a misdemeanor. The biggest issue that we're having with this now, and there's other examples, but I'm just going to give you one. It's with the Groupon for massages at $29. Folks who've never had a massage before will go in and they'll get a massage, and there's OSP involved at that point in time. This is brought on the behest of our Special Victims Unit in Virginia Beach, and working with some folks much smarter than I, we looked at how to fix this, and the best way to structure this was the act is accomplished by false representation or subterfuge that is part of the massage, medical procedure, or physical therapy intentionally and without the consent of the complaining witness. And on more than one complaining witness within a 2-year period, or one complaining witness on more than one occasion. And Mr. Chairman and members of the committee, we know what happened with the Olympics team. That's just a small piece of it. Where we're really having the issue now is with Groupon and massages and things of that nature. When you walk into the massage room and you've never had a massage and the therapist says, take all your clothes off, lay on the table, you expect that to be the standard because all of your friends who have purchased this massage for you have said, hey, you know, massage is a wonderful thing. Next thing you know, you're being taken advantage of. Mr. Chairman, that's all I'm going to go into on this. There are other folks, but we don't want to get into any more graphic than.
And let me just ask you, I know that there, and thank you, I know that you answered a couple of my questions yesterday and helped me understand a little bit better exactly what you were trying to get at, but I know that there was a fairly high-profile prosecution in Richmond involving an incident at a spa, and that perpetrator was successfully prosecuted. Are there instances
misdemeanor,
where
Mr. Chairman.
they're unable to prosecute?
That's correct, as a felony. See, OSP is a felony unless it's under the guise of professionalism. Under the guise of professionalism, there is no force, threat, or intimidation. It's, you expect that, just like the massage therapists under the Olympics, they thought that that professionalism was, you know, that was part of it.
Well,
There
he was
no true
convicted of
force, threat,
felonies.
or intimidation. He was, but that wasn't under the state of Virginia. That wasn't under Virginia law. We're having a problem with making it a felony because under a professional thing, it's a ruse or a guise. It's not part of the FTI.
And I don't think that you get any disagreement from any member of the committee about whether these folks ought to be put under the jail. I mean, I think that's a given. Steve, do you have observations about the adequacy of current statutes to address these situations?
Mr. Chairman, yes, objects, sexual penetration, it either occurs or it doesn't occur. And if it occurs during the course of a massage, I don't know why an individual could not be successfully prosecuted.
Mr. Chairman, if I may.
Senator DeStaff.
If we look at 18.2-67.4, it says the accused is guilty of sexual battery if the sexually abused as defined under 18.2-67.10, the complaining witness against the will of the complaining witness by force, threat, or ruse is a Class 1 misdemeanor.
Can you give me that section again?
It's 18.2-67.4, and then it's under little I. If you now read below, with force, threat, and intimidation, under 18.2-67.2, the accused shall be guilty of inanimate or animate object sexual penetration if he or she penetrates the labia majora, the anus, or a complaining witness, number 2. And then under force, threat, and intimidation, under that portion is where it becomes a felony. So what's happening is under massage therapists or under the physical therapists, it's only coming under 18.2-67.4 because there's no force, threat, and intimidation. It's by force, threat, or ruse. So by the way to fix that is by saying the accomplished by false representation or subterfuge and sliding that under 18.2-67.3 as number 5.
Mr. Chairman?
Senator McDougall.
Can I ask Mr. Benjamin, Senator Stuff, look at 67.2, which is object sexual penetration, same age brackets, I think, or at least some of the same age brackets, but that is mental incapacity or physical helplessness.
Mr. Chairman, I think what the patron is describing to us is this situation. First, I think we're in agreement that if there is object penetration during the course of massage, that's covered by existing law.
As a misdemeanor, yes, sir, Mr.
No, it would be a felony. If there's digital penetration of an intimate part, that is a felony, even if it's during a massage. I think the problem that the patron identifies is that if an individual receiving a massage is touched in an intimate area, that would not be sexual battery because it's not accomplished by force. It would, however, be an assault because the person receiving the massage has not consented to being touched there. And I think the patron intends to make it more than an assault, something having a sexual element to it.
Correct.
And I think that's the spirit or the motivation of the bill.
I believe so.
Okay. What I am unclear on is what is the nature of the ruse? What is the false representation?
That a massage, and these folks who are getting the massages, and this is a good example, that they're going in for a massage or for physical therapy. This is their first time doing it, and they're not certain that that ruse is really, they don't know that that's not part of what's supposed to happen.
Mr. Chair.
Senator Peterson.
Let me ask a question here. I'm just looking at Senator 18.2-67.3 right now, and it looks like it felonizes crimes against people that frankly can't protect themselves because they're children or they're disabled. You're now basically elevating someone who presumably is an adult that maybe they didn't expect the situation they're in, maybe they got false advertising, but you're now, it seems to analogize them as someone that can't protect themselves, but they would not normally be a protected class under this statute. Do you see what I'm saying?
I do.
And so I guess my question is, God forbid, if you're in that situation, don't you have the ability to just stand up and say, hey, I didn't ask for this, I'm not paying for this, don't touch me?
Yes, but
Not that I would know anything about that, but I'm just saying.
the concern is the first-time person going in for a massage under like the Groupon, they don't know what to expect totally. And
Understood.
where this is happening, like, oh, it's standard course. Well, it's
Right.
not standard course.
One further question, I'll be
Senator
quiet.
Peterson.
And I understand that, but I guess my question is, currently the statute felonizes conduct against people that are under a threat of force or are children, as opposed to people that can get up and walk away.
Correct, but it's only a misdemeanor if it's by force, threat, or ruse. It's only a felony, it's a felony if it's force, threat, or intimidation.
All right. Senator Stewart.
Thank you, Mr. Chairman. Senator Steph, I was reading this. This is not limited to the 13 to 15-year-olds. This actually is for everyone. Is that correct?
That's correct. This is set up
All
for
adults.
everyone, adults as
Okay.
well. Yes, sir.
All right. Let's hear from those who wish to speak in favor.
Mr. Chairman, members of the committee, I'm Brian Haskins. I'm the Commonwealth Attorney of Pennsylvania County, Virginia. I'm here on behalf of VACA, and I would state that the Commonwealth Attorney's position is that a object sexual penetration during a massage is not covered by the object sexual penetration statute because it requires, against the will, by force, threat, or intimidation. There is no force, threat, or intimidation involved in someone taking advantage of an individual and doing that to them. I'm well aware of this because I am consulting currently with a case that's pending in a sister jurisdiction on this very same issue where a woman was penetrated digitally by her massage therapist. And the issue is how do we prosecute it? The concern that the Commonwealth has, we are in support of this bill, by the way, is that a massage therapist does not fall under a force, threat, or intimidation because from our experience in dealing with cases of this nature, it is more of a, we're taking advantage of you because of a trusting relationship you have with your massage therapist who's there touching you and you believe that he should be allowed to touch you in that area and actually does so. That is not in the Commonwealth Attorney's position or understanding of the statute covered by the current object sexual penetration statute. For these reasons, we are in support of this bill, and I'll be happy to answer any other questions.
All right. Thank you very much. Anybody have any questions? All right.
Mr. Chair, one quick question.
Senator Peterson.
Yes.
And I apologize. That would still be battery, though, if not aggravated sexual battery. It could,
Yes, Mr. Chairman, Senator Peterson, that's correct. At least as far as the Commonwealth Attorneys Association views it, it would be a misdemeanor sexual battery.
it
But
would not be a felony.
Yes, to digitally penetrate a female against her will.
Or a male, for that matter.
Or a male, exactly.
Mr. Chairman?
Senator McDougal.
Shouldn't we be looking at 18267.2 to craft the definition instead of .4? I mean, the fact pattern that you just laid out, I think, gives us all concern, but doesn't that really belong in the object sexual penetration section?
Mr. Chairman, Senator Dougal, it very well could. The goal of the statute, as I understand it, is to go beyond just object sexual penetration, in which case this would encompass all of that. However, what vehicle the committee chooses to use, we're in support of it.
All right. I tell you what, maybe we ought to act on the policy issue, and if the bill advances, we've got a little bit more time before your subcommittee deals with it to make that technical adjustment.
Mr. Chairman.
And I know that Mr. Benjamin or council have a couple of suggested line amendments if we're going to move forward.
Do they have this version? Okay. Yes, Mr. Chairman, to tighten the bill up a little bit, we would suggest the following changes. On line 24, where it says that the act is accomplished by false representation or subterfuge that is part of a massage, we would amend that to read as follows. The act is accomplished by false representation or subterfuge that is part of a massage by a massage therapist as defined by, excuse me, Virginia Code Section 54.1-3000, and then the rest of that line remains the same. And then in addition, on line 26, where we speak of on more than one complaining witness within a 2-year period, in order to clarify that number 1 and number 2 would both be acts of aggravated sexual battery as opposed to just witness number 2, the language we suggest is in place of what's currently on line 26, we would substitute that with is a second or subsequent offense committed within a 2-year period.
And both of those are technical
That's correct.
changes that don't affect the substance of the bill. Do you have any objections to those?
None
All right,
whatsoever,
is there a
Mr.
motion to
Chairman.
adopt those amendments? It's been moved and seconded. All in favor signify by saying aye. All opposed, those amendments are adopted. All right, and I'm sorry, you have one other witness who wanted to say something.
Yes, sir. It's Lieutenant Gilbert with the Virginia Sheriff's Association. We support the bill.
All right, thank you very much. All right, the bill is before us.
Move to report and re-refer to finance. Second.
All right, it's been moved and seconded to report and re-refer the bill to the Committee on Finance. Roll is open.
Mr. Chairman, members of the committee, thank you very much. Mr. Benjamin, thank you
All
very
right,
much.
thank you.
That's 10 noes, 5.
1149.
Mr. Chairman, 1149.
And I will tell you in advance that we get not an insignificant number of bills every year that deal with DCJS training standards and additional mandates that different members want to impose upon DCJS, most of which are, outstanding, well-intentioned and well-reasoned requests for additional standards. However, problem is that seldom are these standards ever undone that we adopt by legislation, notwithstanding the passage of time and update of procedures. And a number of years ago, the General Assembly established the Committee on Training as the body that is statutorily designated to receive and approve recommendations for training amendments and additions. This has become, and I don't mean to single your bill out, but it is the first of many bills that we have before this committee this year that address this training standards. It would be the chair's recommendation that we pass this and the other bills by, and that we refer this to the Committee on Training for consideration. We'd be happy to hear the particular issue that you would like to have DCJS address.
Mr. Chairman, members of the committee, I have no issues with it going to a training committee that looks at it and incorporates it or not.
And let me ask DCJS, I see Mr. Cotter lingering in the back of the room, and we so seldom get to see his smiling face in here, whether that is something that an approach that DCJS would embrace.
Mr. Chairman, members of the committee, yes, DCJS is currently in the midst of revising its training standards. A job task analysis has just been completed, and now we're going forward with the Committee on Training, coming up with the new training standards that's coming out of that job task analysis for law enforcement officers. So the approach suggested by the chairman of sending these training bills over to the Committee on Training to look at and incorporate into that process.
Is that okay with you, Senator DeStef?
It is, Mr. Chairman, and if I may just explain what we're trying to do real quick, and then I'm happy with it to go over there. I believe our chief sits on the committee that's going to be looking at this, if I'm not mistaken. No? Yes, maybe. Yeah, Chief Severa does. So And Mr. Chairman, what this is just in their training for recruit officers, a lot of the younger officers, when you first become a police officer, it's very difficult to determine stress, trauma, post-traumatic stress type experience in your fellow law enforcement officers. For the most part, it's very similar to our young military members when they're deployed overseas. It's suck it up, buttercup, move on, accomplish the goals, do the mission. And we believe with effective recognition of this, we'll be able to stop a lot of officer-related suicides. As we did in the military, a very similar type thing. I had a lot of friends who took their own lives because they really didn't understand the stress or how to react or how to put it in that box, put the cover on the box and hide it away to where they could address it at the appropriate time. So this just says, hey, we want to make sure people understand how to really recognize it in ourselves and our fellow officers.
And I think this is a very important recommendation, and I know that the committee will seriously undertake consideration. Is there a motion to pass this bill by indefinitely with a letter to the Committee on Training? All right, it's been moved. Is there a second? It's been moved and seconded. Roll is open.
Mr. Chairman, members of the committee, thank you very much. Have a fabulous day today.
All right, thank you, Senator. All right, next we have Senator Barker, Senator Marsden. 1019.
Hey, Mr. Chairman, if I could, some good news here. I'd like to also strike Senate Bill 1081, which is.
All right, Senator McDougal moves and Senator Stanley seconds the patron's motion to strike Senate Bill 1081. All in favor signify by saying aye. Aye. All opposed, that is stricken. All right, 1019.
Thank you, Mr. Chairman. This is a clarifying piece of.
Is there a motion to adopt the substitute?
Yes, excuse me.
It's been moved and seconded. All in favor signify by saying aye. Aye. All opposed, substitutes before us.
Thank you, Mr. Chairman. This is a clarifying piece of legislation. One of the problems we're experiencing around the Commonwealth is ever-increasing timeframes that it takes to get custody, visitation, and support cases through the court. My own county had gotten it back to like 120 days, and because they have 2 vacancies in the juvenile court due to a dispute over appointments, they're now up into the 150s. And what this does is clarify a situation that's occurring across the Commonwealth. In the existing language of the code, some judges are saying that when a petition is filed or a motion is made, that they have to hear it in court to refer it to mediation. And on line 11, what this does is upon the filing of that motion or petition, that the court or its designee, in other words, it does not necessarily need to come before the actual judge. The judge still has the option to do that. But some judges are feeling that they have to bring it into the courtroom.
What is a designee?
The clerk, the staff of the court.
Okay.
And there is that's the first part of it. The second is a sort of a restatement here of existing practice. Which during the orientation session, the mediator shall assess the appropriateness of the mediation referral, and the court shall ascertain upon the motion, and it does not require a motion for the mediator to include that screening for a history of child abuse. So it does not have to be upon a motion. They will automatically do that during the mediation and get that information to the court. And Mr. Chairman, I'll take any questions, and I have a friendly amendment from Mr. Palmore, one-word tweak to the bill.
Well, this is Family Law Day. We have tried to take up all of the family law issues, and if it's okay, I would like to invite the family law section of the Virginia Bar Association to step up and share its thoughts on this.
Morning, Mr. Chairman. Dan Gray on behalf of the Virginia Family Law Coalition, along with Mr. Garriott. We support Senator Marsden's amended bill. The only issue we raised, and I believe the senator was going to get to this, was in line 11 of the bill. We're concerned that the court may interpret the language to mean that there needs to be a separate petition or motion filed to get the mediation. As Senator Marsden said, what should happen is that upon the filing of any petition or motion, the court or its designee should refer the matter to mediation. We just don't want the court to ask, well, does there need to be a separate motion to mediate? And so I think what the senator was going to suggest was that line 11 be amended to say in any appropriate case upon the filing of an initiating petition or motion.
Okay.
Just so that it's clear, but the coalition otherwise supports it for the reasons that the
All
senator
right,
raised.
is there a motion to adopt that line amendment?
Thank you.
Right, it's been moved. Is there a second?
Second.
It's been moved and seconded to adopt that line amendment. All in favor signify by saying aye. Aye. All opposed. That line amendment is adopted. So let me ask you, I mean, in family law is not my area, but what happens in cases where you don't have a willing participant for mediation?
Well, it certainly does happen, but frankly, I practice primarily in Fairfax County, and as a matter of course, because of what the senator said, the amount of time that it takes to get to court, they have been referring parties, particularly in custody cases, to mandatory mediation, and I have been surprised at the success that the program has had. And so certainly there are situations where people are unwilling, but it still sometimes helps. It may be the first time that they've sat face to face.
Yeah, and I support mediation. I believe in mediation. I think mediation works as long as you have two willing participants.
Correct.
But in a case where, for whatever reason, you've got an obstructionist spouse, is this going to slow it down?
No, it wouldn't slow it down. In fact,
Okay.
it could speed up a resolution, we believe.
I mean, even if that obstructionist spouse won't agree to anything.
Well, yes, that's true, but they
It's not
might.
going to slow down getting it before the court.
Absolutely not.
Okay.
Mr. Chair.
All right, Senator Edwards.
It says the court or its designee. Who's the designee?
I think in many systems, certainly in Fairfax, it works this way. The clerk's office might have a docket control system, and so when you file your paperwork, they will generate orders to send people to mediation. I think that's what's intended there,
So,
Senator.
do we, I mean, are there other areas, maybe the guardian ad litem section where, I mean, it authorizes the clerk to do something? I mean, I also have some concerns about designee. I think that's vague.
Mr. Chairman, I think that broader language was used because some places have mediation coordinators who might be the designee as opposed to the clerk.
Is that not a officer of the clerk's office?
You know, I'm not sure what that would be, but that's why we use the broader term rather than just say the clerks.
Senator McDougal.
Mr. Chairman, I guess I have a concern about somebody other than a court, other than it being an order referring somebody. I mean, that is, I mean, I realize that we're going in a procedural direction, but the court should speak by orders. And the court could generate an order in each of these cases with the petition.
There are quasi-judicial functions that the clerk's office exercises, probate function, I do believe guardians ad litem.
Mr. Chair?
Senator Peterson.
What would happen if, say, your spouse takes the child and leaves the jurisdiction, and you need to get immediate relief, and you go in and suddenly a clerk shuts you, pushes you off to mediation for 6 weeks?
Okay, that is, I'm going to phone a friend on that one.
All right. Step back up.
My question is, this is basically saying that now, as soon as you file a petition, let's say a custody petition, you get pushed into mediation without even being able to see a judge theoretically. What if your spouse leaves the jurisdiction with the child? You need immediate relief. I mean,
Well, there-
what good is mediation going to do if they're in Nebraska?
There are two options that you've got, Mr. Chairman, Senator Peterson. Under the current, I can tell you down in Tidewater, they're doing this now where everything is referred to mediation. But the code already provides for exigent circumstances like that. You can either file for an expedited emergency hearing. If you have an existing order and you're going in because the spouse violates the order under the Uniform Child Custody and Jurisdictional Enforcement Act, you can take that order into court, and the act already says you get a hearing within 24 hours of providing appropriate notice to the other parties to enforce that order. So I think there's still, there are avenues that parties can take in these exigent circumstances that this wouldn't hold up at all.
All right, Mr. Chairman. Senator Peters.
Let me just, I'll make, and this is sort of a question/comment, understood, but there are times where you need to see a judge. And I think if our court system has one shining principle, it ought to be, when you need to see a judge, you get to see a judge, not a clerk.
Well,
and I'm just worried that this is diminishing that principle.
And I can't speak for the rest of the Commonwealth. My own experience has been in the Tidewater area where these systems are in, I know Suffolk, Chesapeake, Virginia Beach, and Norfolk all have standing orders where they refer these to mediation immediately. It does not change the docketing process. In other words, you file your petition, you're going to get an order saying you're going to go to a mediation informational session. You need to show up on such and such a day, go to the mediator. At the same time that you get that order, you are given your initial return date to show up to court. So there's absolutely no change, at least in my experience, as far as the docketing of these cases. There's just an initial step that the parties have to take where they go into a mediating process.
But what you're describing is the mediation informational meeting. And I know that the Fourth Circuit and many federal courts have a similar requirement. And I think that somebody else is about to make this point. I mean, I'm concerned anytime that you've got mandatory mediation. I mean, it just seems to, be counter to the whole principle of mediation.
Mr. Chairman, I agree that it seems counterintuitive to say we're going to force you to go and try to come to an agreement. I can tell you that my experience has been, I think the experience throughout the family law world, so to speak, is that even when you have supposed mandatory mediation and the parties go in and they have absolutely no interest in sitting down and coming to an agreement, one may be obstructionist, or in many cases, both are obstructionist. Once they get into that session and they start talking, about 85 to 90% of the time, these cases settle.
Senator Stewart, your point?
Mr. Chairman, the gentleman makes a good point, but I think largely they are voluntary mediations. And what concerns me here is if you have an abused spouse, typically a woman who has been beaten and abused mentally, physically, and verbally by a domineering husband, you're going to force that spouse to go into a mediation session. They could even have protective orders issued, and that I don't think we should be doing that.
Well,
that's why it's discretionary, is to allow for it to be done, and not in all situations.
Mr. Chairman, if I can speak, Senator, if I've read the bill correctly, I may not have, but if I've read the bill correctly, this puts them into they have to go to that initial orientation session. They learn about the process. If they're not going to follow through with it, then they're in court on their normal return date, getting before the judge and allowing the process to go forward. The experience has been, I know, in Hampton Roads.
So that they're not with the opposing spouse?
No.
It's just with the mediator?
They go with the mediator, and then they're encouraged to go to mediation after that.
All right. Thank you very much.
Thank you, Mr. Chairman.
Any other questions? Yes, sir.
If I might, to answer Senator Peterson's a hypothetical situation, the appropriateness language in that line, so that would be an inappropriate referral if that was the case, where somebody was taken out of the jurisdiction or what have you. Is that
Right, but you're having the clerk make decision what's appropriate.
Mediator.
at that point in time, certainly under the standing policies or procedures that the judge lays out for his designee. Remember, this is still optional.
You have
And,
Mr. Chairman.
a supporter who's about to jump out of his skin.
Mr. Chairman, before Senator Marsden walks away, how is it optional? In any appropriate case, upon filing the petition, the court shall refer. It's not an optional
But if you
way
look
for the
at
court to referral.
Look at the remainder of that sentence to a dispute resolution orientation session. I mean, that's it. It's not to mediation,
And
as I read it.
And Mr. Chairman, the court still reserves the option to have these things docketed and brought before them, as opposed to the designee. This just provides the option.
Mr. Chairman.
Is this job security for the mediation specialists?
Mr. Chairman.
$100.
Could
Senator McDougal.
If somebody chooses not to go to that, if the designee sends them, then there's no sanctions that could result from that, correct?
I guess so. Yes, sir.
Mr. Chairman, members of the committee, Mike Sherman. I'm not wearing my typical hat. I'm here today as a certified mediator and a board member with Virginia Mediation Network, CMG, otherwise known as Commonwealth Mediation Group Foundation, and a member of the advisory council along with Senator Marsden on Resolution Virginia. Mr. Chairman, Senator Peterson, Senator McDougal, that portion of the bill is already existing law. What Senator Marsden is attempting to doing is address a difference of interpretation of judges in the court, where some judges are already interpreting the statute to mean that the mediation coordinator, who in some cases is contracted, which is where it's not necessarily a court employee, but the court has contracted with an organization or a coordinator to refer those cases, it's only to the orientation. There are multiple levels of screening for domestic violence and other issues. It is with the coordinator, it is with the clerk, it is with the mediator when the case is referred. The mediator, before they even meet with the folks, has a screening where they're reaching out to the individual members, usually by phone, to figure out whether the case is appropriate for mediation. Senator Marsden's bill is really trying to streamline the process so that there's consistency across courts, so that the existing law of, in any appropriate case, I'm going to rephrase that, all cases shall be referred to mediation orientation absent an appropriate reason or an inappropriate case.
Okay, thank you very much. All right, the bill is before us.
Mr. Chairman.
Senator McDougal.
I guess it's probably just for me. I have some concerns about designee and the shell. I'd be totally fine if the issue is to make sure that courts understand that they can refer everybody in this direction. Then upon filing of the motion, the court may refer all the parents. I
So
think
you would amend line 11, striking where it's designee shall, and replace that with may.
And then
So it would read, the court may refer the parents. That's your motion?
That is.
All right.
Mr. Chairman.
That motion has been, Kristen?
Mr. Chairman, I would just point out, if you look at the original bill, the code section that's no longer in the substitute 20-10 or 124.2 currently says mediation shall be used as an alternative to litigation where appropriate. And then you look at the section that is in the substitute to determine what is appropriate. So that the shall language is in another statute as well.
Shall be used as interpreted. This is shall refer every case. So they may refer every case for an orientation.
Mr. Chairman, and that,
All right, Senator McDougal has moved to amend, seconded by Senator Stewart. And do you want to also amend 124.2? No. To may? No? Okay.
I think that's still okay. This is just.
All right, the motion has been made to amend. Any discussion on that? All in favor of the motion to amend signify by saying aye. Aye. All opposed? All right. Senator Chafin.
So Where does the funding come for the screening for history of family abuse? Who pays for those things? I mean,
Senator
where's that money in our budget?
Marsden, do you know?
I do not. I assume that these services are more available in some courts than in others. And, Mr. Chairman, please.
Mr. Chairman, members of the committee, mediators are paid upon the successful conclusion of the mediation. There is no charge. The mediators are not receiving compensation for that orientation.
Okay.
Mr. Chair, that's not my question. My question was, who pays to do the screening for history of family abuse through the sheriff's department or the state police? It's fee driven. Who pays it? You're going to be getting one of these in every single case now. It's not in the discretion of the court. Who pays for it?
Mr. Chairman, Senator Chafin, I'm confused by where the reference to the sheriff.
Well, Mr. Chairman, there is a fee involved in screening for a history of family abuse. I mean, are you just asking people, have you ever abused someone? Or are you actually going to do a true screening where you do a background check like there is done when there is a home study?
So
or something along
your
those
question
lines?
relates to language on line 16, including screening.
New language, yes.
Right. Which seemingly requires a screening for every case.
Mr. Chairman, Senator Chafin, that screening is actually a part of, if you look on line 14, 8.01-576.4, the sequence. It's in that sequence that, in the case of the mediators, but judges and the clerks, as a certified mediator, in order to do family cases, there's a certification, and in that certification, there's an entire separate class dealing with screening. In order to be certified by the court to do these cases, that training is occurring, but it's different than what you're talking about.
So it wouldn't materially negatively impact the bill to strike including screening for on line 16 since it's already done?
I think, Mr. Chairman, that it's already included in that sequence language.
Senator Chapin, you want to move to strike that?
I will move to strike that language.
All right. That motion has been made. Is there a second? It's been moved and seconded. All in favor of that amendment signify by saying aye. Aye. All opposed? That amendment's made. All right. Bill is before us. All right. There's a motion report is amended. Is there a second? It does not need to go to finance. It's been moved and seconded. The roll is open. All right. Bill is reported. I'm sorry.
Thank you, Mr. Chairman.
Hang on. Let's. Senator Stanley, can you exercise your proxy? All right.
13 noes, 2.
All right. Thank you, Senator Marsden. Next, Senator Saravel. Senator Favola, how many bills do you have?
Just 2 and 1 I'm going to ask to carry over.
Do you mind, Senator Saravel? You can say thank you.
This is the only time he'll be deferring to me, so I'll take note.
All right.
Mr. Chairman, I respectfully ask that we carry over Senate Bill 1092 to next week. The Supreme Court wants to tweak some language, so we're going to give them, I hope we can give them that opportunity.
It's the Supreme Court's fault.
Let's just say they want to be part of the process.
All right, without objection, that bill will go by for the day. Senate Bill 1139.
Okay, Mr. Chairman, this is a very simple bill. What it does is for children who enter the foster care system, it directs the local Board of Social Services to inform the parents, the birth parents or the adoptive parents, that they may enter into a communications agreement And if the child is 14 years of age or older, then the child would need to be informed as well. And that same language is mirrored under the adoption section of the code. So again, if a child actually is adopted, so local Board of Social Services has to inform the birth parents about this opportunity for a communications agreement.
So, and as I read this bill,
Yes.
I wondered what it actually does. Because right now, these post-adoption contracts may be considered by the court, right? What yours does is says that, your bill does, is it says that consideration of the agreement, post-adoption agreement shall be, that the court shall consider these agreements. Is that right?
I think you raise a very good point. And I apologize, there is an amendment in the nature of a substitute.
Huh.
Oh. Where is it?
Where we use may, we use the word may. It should be dated January 19th.
All right. Somebody want to move to adopt the substitute? It's been moved and seconded. All in favor signify by saying aye. Aye. All opposed? All right, the substitute's before us.
I mean, the advantage of this bill is the local social services board is being required to always inform the birth parents about
So what does your substitute do?
My substitute has made, well, what we did is the first part, in any case in which a child has been placed in foster care, we sort of did a technical amendment. We did a small I and a small double I, small 3. And then it went on to, we did have, let's see.
So this simply requires social services to
inform
the
right.
birth parents and the foster parents of the existence of and availability of these agreements.
Correct. And a child, if the child's 14
Are they doing
years
that
of age.
now?
Some of my stakeholder groups did not believe they were doing it consistently or regularly. And we thought that studies show if a child, even in difficult situations, even when families are dysfunctional, there is some advantage to having continued communication with the birth
And
parents.
these agreements
right.
are basically the agreements, these are children who are being removed from their birth parents for abuse, neglect, and this simply, I guess, except in cases of abuse, right, allows the birth parents and the adoptive parents to make a contract concerning visitation, contact.
Communication.
And my understanding is it's, principally used in cases of neglect, often involving substance abuse and recovering people who are in recovery. Is that right?
That's right. And it
Okay.
also would take place for children who are actually placed into adoption.
And I gather the Poverty Law Center has some interest in this bill?
Yes.
All right. Let's hear from them.
Thank you, Mr. Chairman and members of the committee. Valerie LaRue from the Virginia Poverty Law Center. So as the chairman notes, if the abuse was severe or if it falls under aggravated circumstances, then there would be absolutely no obligation on the part of the local to inform anyone about this. And the question is exactly as the chairman surmised, that in
And
some...
is that the Department of Social Services can make that determination? Just a
Yes, because they're the
discretionary
ones
determination?
moving. They're the ones moving for termination, so they would know what section they were moving for to terminate the parents' rights under.
Okay.
When a child doesn't have this kind of agreement, or when the foster parents or adoptive parents and birth parents do not have this kind of agreement, the problem is that the child not only loses contact with that parent, but also with all other relative siblings, grandparents, et cetera. and they lose their ability to know if they have any inheritable diseases or anything that they might be able to or want to find out about themselves. As adults, they wouldn't be able to. It also, I think, encourages some older children who might be reluctant to be adopted because they're concerned that if they become adopted, they will no longer have that connection to their birth family. Those older children can state their wishes. If they're 14 or older, they actually have a right to consent. And so that might encourage more older children who, as we know, are the hardest ones to adopt, to agree to be adopted.
And your concern is that DSS isn't doing this?
Some locals are and some are not.
Okay.
It's jurisdictional.
All right, that's the concern.
Yes.
All right. Family Law Coalition have a view on this?
Yes, Senator, we support the bill as amended.
How about DSS?
Mr. Chairman, we do not specifically have a position on the bill. This is something that has been in our policy and guidance for going on, but I do not have an official
This
governor's
is
position
consistent
on it.
with existing policy?
This is consistent with existing policy.
Do you take issue with the contention that it's not being uniformly followed?
No, actually, Mr. Chairman, we agree it's not being uniformly, even though it's
What are
already
you doing
existing
about that?
policy. There is no mechanism within the bill itself to enforce it other
No,
than say
but
that
you've
you
got
shall.
that policy. Why aren't you all enforcing that policy?
Because there is no enforcement provision, so
But these people are funded by you.
Mr. Chairman, they are actually funded mostly by the federal government, by state government, and local government. So the enforcement, there's a bill
So
that
you
is
have
coming
no
to you.
supervisory authority over that?
Mr. Chairman, there are certain supervisory authorities that Senator Reeves actually has a bill in to try to address some of those. That is Senate Bill 1339 that he can speak to much
Mr.
better than I
Chairman.
can.
Senator Reeves.
The omnibus foster care bill directly addressed this in the JLARC report, the 126 recommendations. And so the first part of that omnibus bill that we have going to the floor now will directly address Carl's concerns and allow them some oversight at the state level. We had no oversight prior to this bill coming through, so.
So that bill, if passed, will enable DSS to enforce its policies?
It will allow
This
him.
policy?
It will allow more authority to do that, and not only do that, but we'll take it one step further. Where we have in the jurisdiction in the Commonwealth DSS agencies that are completely failing, will allow a process to which the state can come in and take those over. Up
All right.
until this bill was passed, we had zero.
Senator McDougal.
Mr. Chairman, the question I have is more around who we're informing. It seems to me informing the adoptive parent or parents and the child 14 years of age or older is 100% appropriate. My concern is the birth parents, even though we might be proceeding under this section, there's no discretion, because even though the department might not be proceeding under an abuse section, there might still be concerns about that, and then there's no ability to have any sort of discretion in that direction. So could somebody talk to me about that part? I mean, the adoptive parents and the children, parent or parents, and the children, that makes 100% sense to me. But is there a reason not to leave some discretion in reference to the birth parents?
Yes, Mr. Chairman, Senator McDougal, I have spoken with Poverty Law Center about this, and I would much rather be may instead of shall, so that it gives me the ability to have the option instead of having a requirement. But Poverty Law Center requested that it stay in as shall. But from my piece of it, I would prefer to have the discretion to be able to make those decisions.
Senator McDougal.
Mr. Chair, I wouldn't mind hearing we just got the substitute minutes ago, so I wouldn't mind hearing from the Poverty Law Center why it shouldn't be may for the birth parents and shall for the adoptive parents and the 14 years of age or older child.
Mr. Chairman, Senator McDougal, my concern is that the termination of parental rights process is fairly long because you have the rights to appeal. And a lot of times the birth parent, after that first termination may decide not to go forward any further and may no longer have any contact with the department. And if they don't know that this is a potential, that no one will ever tell them because they're sort of out of the picture. The statute provides plenty of protections currently because both the guardian ad litem and the department have to recommend this before a court can approve it. So this is really just about letting people know what the law is. And I believe that we should be transparent and let people know what the law is. It doesn't give them a right to enter into it because the court will only agree to it. First of all, the adoptive parents have to agree. And then second of all, a court will only order it if it's recommended by the guardian ad litem and the local department.
All right, Senator McDougal.
I'm just having some concerns about the shall for every situation and that there's zero discretion for the birth parents. I am 100% in agreement that shall for adoptive parents and the child. That makes 100% sense to me, no discretion there, but I do have some concerns about discretion of birth parent situation.
And then Senator Chafin.
Thank you, Mr. Chairman. And this may be both for the Poverty Law Center and the gentleman from DSS. If I understand this correctly, currently DSS has some discretion. And as Senator McDougal pointed out, certainly in the termination cases, we understand, but there are a lot of abusive relationships that have been damaging to a child, and you can think of situations where DSS may not want to notify them of this, but yet now you want them to have to do it. And so why would you want them to do that if these are the people on the ground working in these situations and they look at it and think, we probably shouldn't do it?
And I understand that, Mr. Chairman and Senator Stewart. As someone who has represented parents, I know that many parents are subpar, but not necessarily horrible people. And so, but due to the nature of the proceedings of termination, there's a lot of contention between that birth parent.
Well, I'm talking about I'm not talking about the termination cases. I'm talking about bad cases that don't go to termination. But
They do go to termination. They must be terminated.
All
If it's
the
bad,
always.
the child cannot be adopted unless the parent's rights are terminated.
All right.
And that's why the protection is about subsection E. That's when a parent has been extremely abusive. That's aggravated circumstances, sexual abuse, those kinds of things.
Senator Chafin.
So, Mr. Chairman, again, the concern that I have here is this creates another, something predicate that has to happen or that termination won't occur, okay? That's the rubber on the road here. Just like considering relative placement, and relative placement has to be considered. If it's not considered, the termination won't go forward. The way that this is posed right now with the word shall, very easily, if you cannot give those parents notice because they're not around, they've split, you don't know where they are, any number of reasons, or somebody just doesn't give them the notice, that termination is going to be stopped dead in its tracks. And I think that's contrary to the policy that the legislatures have here.
Mr. Chairman.
Senator McDougal.
I wasn't necessarily thinking in that direction, but that gives me even greater pause for concern. So, Mr. Chairman, I'm going to move that we change that shall on line 19 to may, and on lines 20 after the and add shall inform.
All right. Senator McDougal makes that motion, seconded by Senator Chafin. All in favor of that amendment signify, do you object to that amendment?
I do not. I think that's appropriate.
All in favor of that amendment signify by saying aye. Aye. All opposed. That amendment is adopted. Let's hear, Family Law Coalition have any strong opinion on this?
Did you want the same change?
You need the change in both places.
Yeah, I think
so. You need the amendment in both places.
And I think, Mr. Chairman, just one quick point. I would expect you'd want the same, well, I've got may enter on line 37 in the same place and may consent to.
All right, and Kristen.
But did you want shall inform on line 38 is?
Yeah.
Mr. Chairman, on line 37, you would change the first shall to a may, and then after, right before adoptive parents, insert shall inform.
All right, Senator McDougal makes that motion, seconded by Senator Reeves. All in favor of that second amendment signify by saying aye.
Aye.
All opposed, that amendment is
Mr.
made.
Chairman.
Thank you very much.
Mr. Chairman, just a quick
Senator
question.
Reeves.
Carl, are you good with this now? With it?
Yes, sir,
Okay.
with the discretion, yes, sir.
All right, Family Law Coalition, want to weigh in?
We're in favor of that.
Okay. Bill is before us. It's been moved and seconded. Is there a second? Seconded. The bill as amended report. Roll is open.
Ayes 15, no zero.
It's the first time I've received a unanimous vote from
Well, it's
Courts
a
of
good
Justice,
bill.
so thank you.
Made better. And I know Senator Survell has a bevy of bills. Senator Howell has a witness here for one. All right, Senator Barker, is that okay? And Senator Survell, yeah, actually, you're the next non-committee member. Senator Barker.
Thank you, Mr. Chair. Senate Bill 1279. It deals with situations regarding truancy. It was requested, I was requested to put it in by the Prince William School System. It's been dealing with issues related to truancy and being able to file.
You know, and let me just tell you, I think the lawyers on this committee and the working group had serious problems with this bill, and I will tell you why. This is a bill adding on to a Christmas tree that I'm afraid probably should never been created. What happened was a number of years ago, the Department of Child Support Enforcement was found to have had paralegals signing pleadings for years. And as a result of a crisis pursuant to which literally tens of thousands of child support orders may have been invalidated, this code section was promulgated not because it was believed that we ought to have non-lawyers practicing law, but because we felt the compulsion to protect these children and these families from, retroactive crisis. And this is an incremental advance doing exactly the same thing. Each of these school divisions has attorneys. I know because they spend millions of dollars on their law firms every year. And these law firms and lawyers, their counsel, can sign these orders. And I think that you're going to hear some significant concerns about creating additional areas where we have non-lawyers practicing law.
Right.
So-
I understand. And this, however, I think is much more narrowly tailored and much narrow in terms of what they can do here than the exception that was written in for Department of Social Services staff a few years ago, which you cited the situation that was being faced at that particular time. And what I can do is have a couple of people come up and talk about it a little bit. One, from the school system perspective, but also from the Commonwealth's attorney's perspective as it relates to these types of things.
I'd be real interested in knowing whether the Commonwealth's attorneys are supporting having non-lawyers practicing law in this area.
Yeah.
Becca, have a view on that?
Yes. My understanding is.
Mr. Chairman, Mike Doucette, Executive Director of the Virginia Association of Commonwealth Attorneys. And yes, we do support the bill in the sense that we're still going to have the obligation to prosecute the truancy. This is just to get the matter going. Under Code Section 16.1-268, we have an obligation to prosecute these particular matters. Truancy and getting kids to graduate from school is the #1 way to fight crime.
But and I get that. I mean, the policy is fighting truancy, and we're all in favor of that. But you're supporting having non-lawyers sign pleadings?
We have, I mean, as far as instituting the process, we have that happen all the time. I mean, we have a magistrate system, Mr. Chairman, in which citizens go before and they bring charges that until recently, they could bring felony charges, and we had no say in that particular matter. People bring these matters before us all the time, and when we have not had an opportunity to deal with Class 1 misdemeanors at this particular point in time. This is bringing in school students who are not going to school and starting the proceeding. We still have the obligation to go forward with it.
All right, thank you.
Make sure I'm grabbing your
All right, we'll hear briefly from your school officials.
All right.
Good morning. Thank you for letting me speak to you today. Senator Obenshain, I'm
Sorry for not giving you more of a warm embrace.
That's fine. I'm Mary McGowan. I'm the school board attorney for the Prince William County Schools. And I understand your concerns, and I'm very well aware of what happened in 2016 with the social workers. I want you to understand a couple things. One is that because we were aware of this bill was tailored very narrowly. In fact, it was here in 2017. It passed through the Senate, but there were some objections on the House side, and we took it back and made it even narrower. Also, I'd like the senators to understand that this is basically the brainchild, or the initiative, if you will, of a task force, a juvenile justice task force in Prince William County that's comprised of a player from every piece of the juvenile justice system. The intake officers, the sheriff's department, the police department, defense attorneys, Commonwealth attorneys, et cetera. And it is merely a small procedural tweak we're asking for to expedite the process. The judges are kind of at loggerheads here. The statute gives the attendance officer limited authority to file a chins petition for a child who's in need of services because of attendance issues. That's all the authority they have. When they come to court, the judge almost always enters an immediate predisposition order in which she or he orders the child to come back to school pending the decision on the merits. Many times the students don't come back to school. Procedurally, there's no way to get that child back in front of the court so the court can put in place whatever supports are needed to keep the child in school because of the unauthorized attendance or unauthorized practice laws. So we tailored this very narrowly. It applies only to orders relative to attendance, not to any of the other remedies that the court orders, only to attendance. And it applies, it must be on a Virginia Supreme Court approved form, a simple petition, so we don't have attendance officers drafting pleadings.
Senator McDougall.
Mr. Chairman, I guess I'm thinking of the adult system where a person is on probation, which is a similar type of situation. There's somebody reviewing them. They don't follow the rules of their probation. I got one mail over the weekend, and they send a letter to the court saying, you're not following the rules of probation. We're asking the court to issue a show cause order. Why should this be any different than that? If we're asking law enforcement to go and pick somebody up and detain them, because that's what a show cause is ultimately asking that you do, shouldn't the judge sign off on that?
And the judge would, but my understanding is that probation officers have authority to make those kind of representations to the court and to initiate a show cause hearing, but they don't currently. So the only solution left to the judges, I understand from our J&D judges, if we can't get this tweak, is either for the Commonwealth attorney to assign an attorney just to come down and file this petition, or to put the burden on the probation officers who are already loaded up with more serious offenses.
Senator Stewart.
Thank you, Mr. Chairman. I represent Prince William with Senator Barker, but nobody had talked to me about this previously. The concern I have is, as an attorney under 8.01, we've got a certification of good faith that things are filed. And it always concerns me when you create exceptions to that for folks with pleadings. It's interesting that you mentioned it should be on a court-approved form. I would feel much more comfortable if we let the Committee on District Courts look at this policy decision first. There are a lot of smart people on that, including the Chief Justice, and I think it would be wise for us to run it through that committee before we take any action. Do you have any objection to that, Senator Barker?
No, as long that would be fine.
Right.
I just want to get the process moving so that we can figure out if there is a way to legitimately do that.
I think they can flesh out any issues with it and could be better policy.
Senator Stewart, do you have a motion? Or Senator McDougall, you have a motion?
I think the only motion I can make is to pass it by gently with a letter to the Committee on District Courts to take this issue up for policy consideration.
Senator McDougal seconds the motion. Is that okay?
Yes.
The roll is open.
That really was a friendly suggestion, George.
They didn't get it done this year, but we're headed.
You're making
we're
progress.
Making progress, and that's what we want to do here, to be able to find
All
a right
right,
solution.
Senator Barker, next you have, you had Senate Bill 1285, which I believe was identical to this bill.
Yes, I had a change in legislative aids, and both of them filed.
You want to strike that?
No, so, well, we could try it again here, but the outcome might not be any different, so I would suggest that we
strike it.
Yes. So.
All right, without objection, 1285 is stricken. All right, Senator Howell.
Thank you.
Was that all, Senator Barker?
Yes.
Okay.
Thank you, Mr. Chairman. I have 1395,
All right.
and there's an amendment in the nature of a substitute for that.
All right, Senator Howell moves the substitute. Is there a second? Second. All right, it's been moved and seconded. All in favor of adopting substitute, signify by saying aye. Aye. All opposed, substitutes before us.
Thank you, Mr. Chairman. Healthcare providers, particularly nurses and emergency room medical staff, face challenging situations every day in service of their community. In 2017, we expanded the application of minimum penalties for assault and battery on healthcare providers. This bill, as amended, affords them certain protections that we already provide to teachers and school employees in performance of their public service duties. Currently, it's a Class 1 misdemeanor to make oral threats to school employees while on a school bus, on school property, or at a school function. This amendment, in the nature of a substitute, extends the same penalty for verbal threats to healthcare providers in a hospital or emergency care facility setting when the individual knows that the person is indeed a healthcare professional. This not only helps provide necessary protection for hospital workers, but it also provides clarity for law enforcement. Verbal threats can have a significant impact on an individual's personal safety, as well as the performance of their life-saving work. I've invited Jim Cole, President and CEO of the Virginia Hospital Center, to share some information about the current situation his employees have faced over the past several months. Unfortunately, this story isn't uncommon, and I believe it's important that we support our health providers through this code change.
Right. So, and let me ask counsel, this has at lines 29 and 30, other facility rendering emergency medical care. What is that? I mean, is that a defined term, or, I mean, is that back of an ambulance, or?
Mr. Chair, that language does appear in 18257, the assault and battery statute against the health. It does. Okay. So it would just be the plain meaning of a facility rendering emergency medical care.
Right, and a threat to do bodily injury. Steve, what is that?
It's a threat to do bodily injury.
I'm going to kick your butt.
Yes. Yes.
All right.
Mr. Chairman.
Senator McDougal.
While you're asking, who is covered under that 801-581.1? So if you walk into the ER, there's usually some intake individuals that are there. Are they covered under that definition?
Mr. Chair, healthcare provider means a person, corporation, facility, or institution licensed in this Commonwealth to provide health care or professional services as a physician or hospital, dentist, pharmacist, registered nurse, or licensed practical nurse, or person who holds a multi-state privilege to practice such nursing. Nurse practitioner, optometrist, podiatrist, physician assistant, chiropractor, physical therapist, physical therapy assistant, clinical psychologist, clinical social worker, professional counselor, licensed marriage and family therapist, licensed dental hygienist, health maintenance organization, or emergency medical care attendant or technician who provides services on a fee basis.
So, Mr. Chairman,
Sir McDougal.
if a person doesn't meet one of those licensee requirements and they're working at that front desk, somebody can go in and threaten to kill or do bodily harm to them, and it's not a Class 1 misdemeanor. But if a RN or a doctor comes out of the back and they say it to them, then it is a Class 1 misdemeanor.
I believe that's correct, Mr. Chairman. I would note that that language, though, again, does appear in the assault and battery statute. So you'd have the similar problem of the person coming in could hit the person working behind the desk, and it would not be the aggravated assault and battery against a healthcare provider. But if they did hit the physician or licensed professional, it would be the aggravated.
Mr.
So
Chairman,
it's just matching up that.
Let me ask one other question. So if there was a off-duty law enforcement or security guard and the person made that same threat to kill or do bodily injury to that person, would that be a criminal offense in that same location of the hospital or facility rendering emergency medical care?
It would not be covered under this bill. Law enforcement would not be covered.
But, Mr. Chairman, bear in mind that we're talking about just words. The moment somebody raises their fist, then they're committing an assault.
So, but if you said those words to law enforcement, it's not an offense, but if you say it to RN, it is.
Right.
In the same place.
Right. And, Mr. Chairman, earlier, you were correct. We jumped from threat to kill to a mere threat to do bodily injury. And I say mere only because bodily injury could be anything, no matter how trivial.
Okay, we'll gladly listen to your witnesses.
Chairman O'Machain, members of the committee, thank you. I'm Jim Cole. I'm CEO of Virginia Hospital Center in Arlington.
Welcome.
And I'm pleased to be here to express our appreciation to Senator Howell for introducing Senate Bill 1395 on behalf of our hospital workers and support her efforts to provide some additional protections from oral threats made to healthcare workers in an emergency setting. I want to be respectful of your time, and I realize that you don't legislate based on anecdotes, but I think one example might help to make this very real for you. This past summer, a patient who has visited our emergency room several times visited again. His nurse was a young lady who was pregnant. He threatened to follow her home, rape her, and kill her children. Now, because his threat was not in writing or in an electronic form, the magistrate was not able to take any action. This individual visits on more than one occasion. And as you know, unlike other businesses, federal law prohibits a hospital from refusing service to a patient. So our hospital workers are often subjected to these types of oral threats. And while we do our best to manage individual situations like this internally, we believe that it's good public policy to afford emergency workers with the same protections already afforded a variety of other professions, such as those in policy, first responders, or teachers. I hope that the committee will act favorably on Senator Howell's legislation. We believe the bill is narrowly crafted to simply extend the protection already afforded to a variety of professions which interact with the public on a daily basis.
Let me ask you a question.
Yes,
Did you all assist your nurse in getting a protective order?
We have gone to the magistrate, and in fact, The magistrate one nurse was able to obtain a protective order. However, this threat's been made to many. And the hospital, in an effort to protect all of its staff, in fact, was able to get a no trespassing order. But what I'd like for you to understand, no trespassing on hospital premises. What I'd like to emphasize, though, is the catch-22 is that this patient has been back and others come back to the emergency room, where even though we have a no trespassing order, we are required by law to render an emergency evaluation by the same staff who've been threatened.
Okay.
Mr.
Thank
Chairman.
you.
Mr.
Thank you.
Chairman.
Who's that? Senator Stanley.
Sir, if you,
Pardon. Yes, sir.
Sorry.
I have a question. So it sounds like to me, especially with the multiple visits to the hospital without disclosing any medical information, and this might fall along that same line, a lot of you in the hospitals, you're seeing a lot more admittance with people with mental problems, are you not? TDOs.
That is true, yes.
Okay, and you're having to handle those, and sometimes they're accompanied by a police officer too, is that correct?
In those cases, yes.
Mr. Chairman? Mr. Chairman?
Senator Stanley.
So what do we do for this bill doesn't seem to carve out or address, so we have a mentally ill person who comes in your hospital, voluntarily, involuntarily, whatever the circumstances, and during their psychotic state or something, make a statement that would be considered a threat of bodily injury. Even to the degree of Senator McDougal's, I hope you get a paper cut. I mean, Mr. Chairman, my understanding is that they would be guilty of this Class 1 misdemeanor, correct? Without regard to their mental state.
Mr. Chairman.
Because they intended to say it. I don't think you can have not guilty by reason of insanity for that.
Mr. Chairman, we tried to address that in the language on line 30 because the person needs to know or has reason to know. He threatened the healthcare provider. People who are in mental health crises wouldn't fit that standard.
Okay.
Says who?
Let's hear from your other witnesses while Senator Stanley cogitates over that.
Cogitating.
All right. Yes, ma'am.
Hi, my name is Melissa Early. I'm a board member for the Virginia Nurses Association. I would like to thank Senator Howell for bringing this bill and the chairman and the committee for hearing me. Workplace violence in healthcare is a growing problem in the Commonwealth and across the nation. I stood before this committee 2 years ago and talked about my own experience with workplace violence as a nurse working in a hospital. On November the 19th of 2015, I sustained a devastating injury at the hands of a patient. I won't belabor you with the details of that incident or how that injury is still negatively impacting my life. What is relevant and important for me to share with you today is this. The patient that caused my injury that has changed every area of my life likely would not have happened if this bill were in place in 2015. That morning, the patient was told she was to be discharged. She was not happy with that news. She told me that she was going to hurt me if she was to be discharged that day. I had absolutely no recourse as a result of that threat except for to wait to see what would happen. What happened is she followed through on that threat and she severely injured me. So I ask you that you please support this bill. I would like to make a comment in response to the question that you had. I've worked in mental health for approximately 30 years. There is a very, very slim margin of folks with a mental health diagnosis that don't know right from wrong. Very slim. In those cases, and in folks who are brought into the ED under an ECO, they're typically in handcuffs and closely guarded by a law enforcement officer. They're being evaluated for their mental state. So while they're being evaluated, it's being taken into consideration that they may not know right from wrong. They may not be in touch with reality at that time. So it's being decided whether or not they need psychiatric admission. So in that case, they would not be considered responsible for many of the statements that they make. I don't know if that answers your question.
It does, Mr. Chairman.
Thank you very much for being
Mr.
here,
Chairman.
and thank you for sharing your personal story. I appreciate that.
Thank you.
Yes, sir.
Good morning, Mr. Chairman, members of the committee. Brent Rawlings with Virginia Hospital and Healthcare Association. We support this legislation, work with Senator Howell to bring it to place for our members in their efforts to support their healthcare workers. You look at some of the numbers nationally, healthcare violence in the workplace. OSHA reports that 75% of nearly 25,000 assaults that occur in a year occur in the healthcare workplace. In many ways, healthcare facilities, emergency departments are becoming the public square. And we mentioned some of the issues around police, law enforcement, and why are they treated differently. We have to remind ourselves this is a place where healthcare treatment is being procured and rendered to individuals who are in need of help, and those workers need our support. One thing I did want to point out, Senator McDougall, you asked about the front desk worker. Further on down in the definition of healthcare provider, it references individuals who are employed or engaged as related to healthcare professional services. So that definition is pretty broad and all-encompassing of individuals working within a healthcare provider setting. At the very end of that definition,
Mr. Chairman.
Senator
Well,
McDougall.
the definition says who is engaged in the performance of his duties, number one, in a hospital, two, or emergency room, or premises, or clinic, or facilities. So the requirement there is they have to be engaged in the performance of their duties. Doesn't say engaged in the performance of medical duties or emergency duties, anything. It's just in the performance of his duties. So you have to have a provider, and I would say a RN, if they are dealing with a patient for workers' comp situation, you're going to say they're involved in their duties if they are anywhere in the hospital, not on break doing some sort of work. So there is a difference. And I think the real question I have is, I mean, words being a criminal offense. I mean, there are a multitude of situations, and that's what many of us are struggling with, the words being a criminal offense. Because if there's any action in support of those words, then that is always a criminal offense.
Mr. Chairman, Senator McDougall, if I may, I understand the concern there. We also have to keep in mind that with the statute that passed 2 years ago that created the battery for healthcare providers, expanded the scope in the last 2 years, there have been 63 assaults and batteries. So these events are happening in the emergency department, and so when people are threatened with harm, they have every reason to legitimately fear that. And I'd also point out that this language appears in the same code section related to teachers and school workers. We would have the same issues, questions, and concerns there about threat. It's the very same language that applies there. It's existing in the code. We're simply just relegating this over to healthcare providers who need that additional protection.
All right. Thank you very much. Anybody wish to speak in opposition to the bill? All right, the bill is before us. It's been moved and seconded that the bill be reported. I don't think, does it have to go to finance?
No. So, Mr. Mayor.
It does not have to go to finance, Mr. Chair.
You want to make a motion to send it to finance? All right. The motion is to report the bill.
Ayes 9, noes 5.
All right, the bill reports.
Thank you, Mr. Chairman. Did you want me to do 1078 now or later?
Let's do it later.
Okay.
All right. I guess we have the tranche of Surville bills. All right, we're going to move through these.
Yeah, you've seen several of them before.
All right. First bill is 1539.
Right.
This is a bill that we did hear last year. It reported on an 11-4 vote dealing with.
No, not 1539.
Sorry. I'm sorry. It failed to report on a 11-4 vote last year dealing with withholding of income for child support from transportation networking contracting drivers, right?
Close. It's a bill that would allow DCSC to withhold child support from independent contractors who, where people earn more than $600 per year from that contractor. And last year, Senator McDougal and Senator Peterson expressed concern that the way it was drafted, because of the way it was drafted, we might be changing the law on independent contractors and employees. And so we went back to the drawing board and redrafted it to take away the mixing of definitions and sort of clean up the drafting is what we did. Just for some really quick background, more and more people are moving to this gig economy, and Uber, Lyft, Airbnb, 1099 employment. And I just handed you an article about a study that was done by the Pew Charitable Trusts, which talks about how the current gig economy is giving child support deadbeats a place to hide, and so their income doesn't get withheld. Uncollected child support in Virginia is now $2.5 billion. We have $2.5 billion that, and if that's not paid by these payees, it's paid by social services, so it costs taxpayers. So what I did with the bill this year was we made several changes. Number one, instead of combining independent contractor and employee in the employment code, we just added the term independent contractor throughout the code. We did that. We added some enactment clauses at the ends of it that makes it clear that we're not changing the law on what an employee and what an independent contractor is, because that, again, was a concern that was raised by everybody. And I think there was one other change, I think, which I can't remember. Ms. Walsh might remember what it was, but she helped write it.
I think we made it clear that it was for $600 or more in a couple of other places
Right.
throughout the bill.
Right. So, we tried to address the committee's concerns.
All right. Do you have anybody who wishes to speak in favor of the bill?
No, last year, DCSE was in support of the bill. This year, they're ambivalent about it, but they help provide feedback to get it to where it is.
All right. Poverty Law Center loves bill. Family Law Coalition loves the bill. Anybody in opposition to the bill?
Is it?
Hang on. Not so fast.
Mr. Chairman, members of the committee, Nicole Riley with NFIB representing Virginia small business owners. We just have concerns with the bill, just in the burdensome aspect for this for our members. As of 2017, when we did a survey of our members, 51% still do all of their payroll in-house. So for a lot of them, this could be a burden from them, just in the way of reporting and the mechanism by which they'd have to do this. Thank you.
Mr. Chairman, Rob Bohannon representing the Virginia Retail Merchants Association. And one of the concerns we have is with independent contractors. Some of our folks, like an Amway or a Mary Kay, they're considered independent contractors. And a lot of those folks don't sell a lot. And there's a lot of folks who do that for, minimal reason, and they could get pulled up into this.
So if that threshold were raised from $600 to another higher figure, would that address your concerns, Rob?
Probably. I'd be happy to talk to our client and see.
You want to raise that to $5,000?
It's fine with me.
Mr. Chairman,
I'm not sure how many Uber drivers make $5,000, but.
My question, if you're a we went through this lengthy discussion about the TNCs and whether they're employed by Uber, Lyft, or whatever company, or they're independent contractor. If you're an independent contractor, you get a you're the employer 1099s them, and they don't go through any determination about anything at all. If you're an employee, anything over $600, you have to provide a W-9. So that, I think, is the question. What if you hired a babysitter and they, to work or summer care, and you paid them $1,200 you're supposed to 1099 them. And you do that, are you supposed to then do withholding for them?
If you're hit with a child support withholding order, you would be. You'd have to get a child support withholding order served on you as an employer.
So unless it's served on you as an employer, you've got no obligation.
Right, this does create, I don't know, there are obligations to report to VEC once you hit $600 that you've employed somebody, and DCSE checks that database to figure out who to hit with the employment withholding orders.
Okay.
I think that's right. Yeah.
All right.
Mr. Bersham's nodding his head.
Okay, the bill is before us. So motion to report, properly seconded.
Ayes 12, no zero, abstentions 2.
All right, that bill reports, 12
Thank
to
you.
2. Congratulations.
Thank you. Okay, 1540 is a bill that you all have seen 3 years in a row. It passed out of here 14-1, 15-0, 11-3. Came out of the Senate 39-1 last year. There's one change to it. Or, I'm
So
sorry,
make it better or worse?
One amendment needed and one changed. So the amendment is, I've talked to the Supreme Court, and in light of some form changes they've made, I'd like to strike 308 through 312, which is some of the new language.
308 to 312. Is there a motion to strike that language? This is translation.
Yeah, that takes away a fiscal impact, and the Supreme Court didn't really like it.
All right, it's been moved and seconded to strike 308 to 312. All in favor signify by saying aye. Aye. All opposed, that language is stricken.
Thank you. The only change, sorry, Mr. Quagliato has a question.
Mr. Chair, I believe that language also needs to be struck on 134 to 138.
That's true.
All right, is there a motion to make that amendment? It's been moved and seconded. All in favor signify by saying aye. Aye. All opposed, that language is stricken.
Okay, and with that
So-
change, the only other difference in this bill besides the ones the committee has approved before is on lines 22 and 23. I added a provision to this that says that if a protective order is appealed to circuit court, that it has to be expedited on appeal, which is consistent with how protective orders are treated in the district courts. At least in my experience in Northern Virginia, the courts will sometimes take as long as 6 weeks to docket a protective order appeal, which is just too long. And I believe that everybody I've spoken to is okay with that change who does protective orders.
Mr. Chairman?
So this requires it to be docketed within 48 hours?
Of the appeal. Of receipt, 48 hours of receipt of the appeal.
Mr. Chairman?
Senator McDougal.
So if you are found to be covered under protective order, you have 10 days in which to note that appeal. So somebody a week or so ago is found to be covered by protective order. On Friday, the last day, or this, let's say last Thursday, they go into district court or juvenile court, because it could be either, note that appeal, that court sends it up on Friday afternoon, and it's not docketed over the weekend, they've missed the 48 hours, right?
Close. What happens is, once you note your appeal, the district court clerk actually doesn't like immediately carry the file upstairs. Sometimes it takes a day or two or three or a week. And once the papers are received by the clerk, the actual file is received, they need to give it a case number, because sometimes it goes in a big stack of stuff and they don't give it a case number, so you can't do anything with it. This just requires to be given a case number, not put on the docket for a hearing, but just given a case number so somebody can do something with it.
Mr. Chairman?
Sir McDougal.
So, well, let's say I have an efficient district court clerk, because I'm sure every one of mine that I come in contact with are extremely efficient. They get that appeal written notice from the subject of the complaint. They hand walk it upstairs to circuit court, give it to a circuit court clerk on Friday afternoon or Thursday afternoon, last Thursday. Have a 4-day weekend. Wouldn't you at least want to say 48 hours, like 2 business days?
Sure, it's fine with
I
me.
mean, because right now you have it, if somebody gets on Friday,
Right.
if it's not done by Sunday, it's.
That's fine. If you want to do that, that's fine. I'm just looking for it to get a case number, not actually go on a docket for a hearing.
Mr. Chairman?
Sir McDougal.
Could the Supreme Court come up and say, and maybe Mr. Dix, does docketed mean the same thing everywhere?
I can tell you, Mr. Dix looked at all my bills for a day, and he left after he told me he was cool with all of them. Is he back?
Except he's
Oh,
standing
back.
right there.
Yeah. All right, there he is.
He came back just to tell us that docketed means something similar or different in every circuit court.
Mr. Chairman, I did spend a lot of Sunday looking at Senator Servel's bills, but I would say that the 48 hours on a business day makes good sense to us. And if it says assigned a case number, that would be more appropriate, I think, as opposed to docketed.
Okay.
You want to make that?
Mr. Chairman, before I make the motion, the Supreme Court is back there. I don't know that they're excited to come forward, but I'd love to hear from them.
Good morning, Mr. Chairman.
Good morning.
Members of the committee, Alyssa Patton with the Office of the Executive Secretary. I would defer to Mr. Dix as to the circuit court clerk's docketing procedures, but I don't see any particular problems with the amended language that's been proposed.
All right.
Mr. Chairman, I have a
All
question.
right, the amendment's been moved and seconded. Does your question go to the amendment?
It does. What's the difference between docketing and assigning a number? Aren't they the same? I thought when they docketed, they assigned a number.
Mr. Chairman, I would say to Senator Edwards, I think that it means different things to different people. I don't know that it's a defined term, but everybody knows what it means to assign a case number, which means the case is opened, which is what the Senator Servel's language is trying to get to.
Mr. Chairman,
Senator
as I
Edwards.
recall, docketing is a technical legal term. For example, if you take a general district court judgment and you have to docket it in the clerk's office in order for it to be a lien on real estate. That's just one example.
So, Mr. Chairman, I would say that when you docket a document for recordation and a judgment, or you docket a hearing, there's a number of ways that docketing is used. Here, it's not defined. I think the easier way, since we're all talking about the same thing, is assigning a case number.
All right.
Yeah, I'm fine with
there's- The motion to amend's been seconded. It's before us. All in favor of the amendment signify by saying aye. Aye. All opposed. All right. The amendment is
Okay. And with
adopted.
that change, the bill is otherwise in the same form. This committee's approved it 3 times, and the Senate approved it 39-1 last year. The same people have an objection to it as have had it in the last 3 years, and I think they're here to speak.
All right. And the other thing that this bill does is it requires the court to include in its order the basis for the protective order summary.
If there's no affidavit.
All right. Okay. All right. Those who wish to speak in opposition of the bill?
Good morning, Mr. Chair. Sushila Varkey on behalf of Virginia Poverty Law Center. I've expressed my objections in the past because of the requirement of a summary of allegations and findings might have a chilling effect on judges actually doing that. And that would prevent victims from being able to have access to an ex parte order. So what I would say this year that I learned, which is different, the protective order petition form has been changed recently to include more lines in the petition for the petitioner to express some of the things that Senator Surville is looking to obtain from this bill, right? So I would say that eliminates the need for this bill. If you have a petition that is expressing more of the details of the basis, the act, the date and time, I think that should be enough for notice for the respondent.
All right. Anybody else wish to speak in opposition to the bill? All right, and as noted, this bill rolled out the Senate last year. Is there a motion on the bill? Second. It's been moved and seconded. The bill be reported as amendment. The roll is open.
Ayes 15, no zero.
All right, you're doing pretty well. You want to double down?
Absolutely. These next two, I think, are a piece in the valley, so.
Let's see.
So say you.
Okay, so 1541. As I told you, I tried to keep to my greatest hits this year, given my limits.
Thank you.
So 1541, basically, this just tries to simplify the no-fault agreed divorce filing procedure. Right now, if you want to file a no-fault divorce proceeding and everybody's in agreement, you can't get the person on the other side to sign a waiver of service of process until the complaint's been filed, which is crazy. The clerks won't let you waive process until you filed the complaint. And so all this does is it says you can sign a service waiver before filing the complaint, and you can file the whole package with the court instead of having to do two separate filings, as long as the service waiver is done within a reasonable time of when the complaint's filed. And it simplifies the no-fault process, and I think everybody's okay with it. I think there might be I think there's an amendment. Yeah, there's also an amendment, a floor amendment that I think the clerks requested.
Kristen?
Right? No amendment? Okay, sorry, I got, oh, okay, no amendment.
All right. Anybody wish to speak in favor of this bill real briefly? Family Law Coalition loves it. Poverty Law Center loves it. Yes, sir.
Thank you, Mr. Chairman and members of the committee. My name is Mark Dray, and in my dotage, I've been a long-time partner at Hunt & Williams. I've done no-fault divorces, and what I'm trying to do in encouraging you to report this bill out is encourage more people to do no-fault divorces on a pro bono basis that would simplify, and this bill would simplify the process and thereby, I think, attract more people to doing this. We'd have more access to justice, and it would take a lot of time for courts and clerks to process these cases that are basically agreed to cases by the parties.
All right. Well, thank you very much. Mr. Dix?
Chairman, the clerks support this bill as in the substitute form. It gives us the authority to accept the waiver.
We don't have a substitute.
No okay, well, it was a substitute that we worked on.
So you oppose the original?
No, we're fine, Mr. Chairman. But it gives us the authority to accept the waiver when we don't have the authority now.
So in any other civil case, can I have somebody sign a waiver before I file suit?
No.
Chairman, I would say no because there's no pending case.
But in this case, you want to do that?
So in
Okay.
this case, Mr. Chairman, we believe that if the parties get together and, as Mr. Dray has represented, put this package together, then if the waiver is signed before the case is filed, that's okay, as long as we can process the case when it's filed.
All right.
It's not a case number.
Because,
Senator
Mr. Chairman,
McDougal.
I guess in other civil situations, the parties, if they came to a meetings of the minds and resolved it, it would be the exchange of finances or goods, and there would never be a case filed. The only way to resolve these cases is through a court order, a final decree.
Mr. Chairman, I'd say that's absolutely correct.
All right. Bill's before us. It's been moved and seconded the bill be reported. All right.
Ayes 15, no zero.
Pushing your luck there.
Is this your 26?
All right, 1542.
There's a substitute on that one.
Is there a motion to adopt the substitute? It's been moved and seconded to adopt the substitute. All in favor signify by saying aye. Aye. All opposed. Substitutes before us.
Okay, this is another one that Poverty Law Center requested. It has to, again, to do with no fault, or not, actually doesn't have to, yeah, no fault divorces, as we've limited to no fault divorces. Back in 2017, we passed legislation, it has to do with the waiver of filing fees for divorces. Back in 2017, we changed the code to say that you could get your filing fees waived if you would otherwise qualify for court-appointed counsel in a criminal case. And that's created some inconsistent practices across the Commonwealth in terms of how that's processed. Some clerks ask more questions than others, and others, if you say you're receiving federal or you're receiving government benefits, that's sufficient. This substitute just makes clear that if you're proceeding with a no-fault divorce and the person certifies that they are receiving public benefits, that there's no more questions asked in terms of getting the waived the $49 filing fee. So hopefully that'll, again, expedite the filing process and, again, encourage more people to bring these things. And right now, instead of the clerk asking some people 20 questions about their income and assets and whatever, they just certify they're receiving benefits, they can file without a filing fee, which is, I think, what our original intent was.
Yeah, and before getting into the substance of the bill, line 22 or 2122 requires a certification of receipt of such benefits before a notary or clerk. Not seen that language before. Shouldn't it be under oath or under penalty of perjury or appropriate language?
I think there's some form, Valerie can explain, I think there's some form that they have to do which has that language in it, but.
But isn't it under oath?
She would know better than me. Go ahead.
Mr. Chairman, most courts have the person sign an affidavit anyway when they're, so that would be under oath.
But if you want to add under oath, it's fine.
But that's fine as well.
Mr. Chairman, I agree with under oath, but I have a separate question I want to ask Senator Servo.
All right, so strike line 22 and insert under oath?
Mr.
do
Chairman,
it?
traditionally in the past, when we have made things under oath or under penalty of perjury, then they get a corrections impact because the penalty for perjury is a Class 5 felony.
Well, and I understand that, but, you know, we're not going to create new language just to avoid a corrections impact. I mean, I don't think that's appropriate. I think if it has I mean, if we're going to put that language in and require them to do it under oath, they need to do it under oath. So is there a motion to make that amendment?
So moved.
All right, the amendment is moved and seconded. All in favor signify by saying aye. Aye. All opposed? All right.
Mr. Chairman, my question for Senator Servo is it's the not rebuttable language.
The
So
what?
if I am watching the Powerball come back and I see Joe Smith won the $80 million Powerball, and the next day they come in with their no-fault divorce decree and say, well, I'm receiving public assistance, and right now we still require them to tell us about they're receiving lottery funds, why is the not rebuttable language there needed?
Just point out, first of all, that we said that Powerball winners can ask their names be secret from now on. I voted against that.
But today they're public, and that's why I'm pointing it out. So isn't the same argument the one you made on the floor, that if there's something else, why would you want that not to be rebuttable? I don't have a problem with the other, but I mean.
And to follow on with that, I mean, come on, I mean, in, 99.99% of the cases, isn't it adequate to say that there is a presumption? I mean, who's going to rebut that presumption?
I think that's what the current, Mr. Chairman, correct me, I believe that's what current law is by referring to 19.2159, which is what's caused these inconsistent practices with some clerks requiring you to prove your income and assets and everything else to save $49.
But doesn't this do that, still provides that framework for how you establish that presumption,
Does what provide that framework?
saying that if they're a current recipient of state or federally funded public assistance benefits.
I think on this sub, all you'd have to do is certify it, and then that ends the inquiry. If there's
Yeah, I
no
know,
per-
but
rebut-
to
rebuttal.
Senator McDougal's concern, maybe there is, I mean, and this is not, this isn't going to change the rotation of the earth, but, I mean, isn't there going to be, I mean, doesn't that, protect the cases that you're concerned about, but provide that outlet for cases in which there truly is some fair, legitimate reason to dispute that the person is indigent?
I would defer to Mr. Dre on that.
Let me just speak to that for
He
1
lives
minute. I
this
mean,
every day.
we're again talking about access to justice. And what I found in doing these cases over the last 3 or 4 years is that different courts either automatically approve it if you're getting these benefits, or because it's been tied to the criminal statute, they drill down on it. Or third, we've had courts that ask us to actually move the case to another jurisdiction. They will not waive fees even if someone is receiving these benefits. So again, my reaction is if you want to encourage access to justice, more people to help people get access to justice, worrying about a $42 filing fee, it just doesn't merit,
Mr. Chairman.
Senator McDougal.
leaving it rebuttable.
What, Mr. Chairman, then we should say, if you receive these benefits, you shall not pay the fine, the fee, instead of rebuttable. I mean, there's a myriad of situations. The lottery, somebody is on public assistance and they get a docketed personal injury claim, and all of a sudden they decide that they don't want the person that they're married to have some access
If they're
to.
getting these benefits.
Well, but
they're
Mr.
not-
Chairman,
don't pay
so
the cost, yeah.
I don't understand why we wouldn't say the presumption, leave and have that. It doesn't, either you're going to say, if you're getting the benefit, you never do it, or create a actual presumption, not a, I don't know.
All right, so do you want to make a motion to amend?
Make a rebuttal?
Make a rebuttal. I think we've got the parameters of the issue.
I got maybe a better fix, Mr. Chairman.
Do tell.
My amendment would be on line 18, strike provided that and say, except in the case of a no-fault divorce proceeding under such and such, where the person who is a current recipient of a state or federally funded public assistance program for the indigent, period. That brings in the rebuttability, I suppose, but if the person can prove that, then they don't have to go through the factors under subsection B of 19.2-159.
It sounds like there's agreement about rebuttable. It's just a question of where you put it in the sentence. So I would think Kristen could figure that out if that's the committee's will.
Can you figure it out, Kristen? His amendment was strike provided that,
Say except.
put except in the case of, so basically, the court shall, never mind. I don't think that makes sense. I don't think that works. Right. All right, anybody have an amendment, or shall we move on the bill?
I'm going to move to strike, shall not be rebuttable.
All right, so motion, is there a second? It's been moved and seconded to strike shall not be rebuttable. All in favor of that amendment signify by saying aye. Aye. All opposed? All right, that amendment is made. The bill is before us. It's been moved and seconded. The bill be
Mr. Chair,
reported.
I'm sorry, can
I'm
we
sorry.
just hold up for a second? So it would read, provided that in the case of a no-fault divorce proceeding, the presumption that a person who is a current recipient of state or
There shall
federal...
be a presumption.
There shall be a presumption.
Right. That's what your motion was, correct? Okay.
Got it, thank you.
All right, there's a motion to report the bill as amended. The roll is open. Senator Servell, you're on a roll.
Maybe I should be in favor of bill limits. I don't know.
We want to keep you busy during the remainder of session.
Mr. Chairman, I heard that Senator Servell is going to support the bill limit of 15 next year.
There'll be really good bills. All right.
1544.
1544.
This is a bill you all saw last year, and there's absolutely no changes to it. So
What
just
do
to
we
remind
do?
everybody what it does.
This bill failed to report on a 6-8 vote last year. And it is in identical form.
Yep. So just to remind the committee what this does, this bill has to do with assisted parentage. That's surrogate parentage with same-sex couples. So after the Obergefell case came down, where same-sex marriages are now accorded the same status as heterosexual marriages, our code is out of compliance. And the Commonwealth, I think, is subject to a due process challenge because we haven't changed things. And to remind the committee, everything after the first page of this bill was recommended by the Code Commission. It sort of takes out gender-specific terms and replaces them with spouse, 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 pretty much. The first page, what the first page does is it takes the common law presumption about who a parent is when a kid is born and codifies it. It's called Lord Mansfield's rule, and this language is taken from the Uniform Parentage Act. And what this would do, it would mean that a same-sex couple no longer has to do an adoption in order to make a child the child of both parents. So, for example, right now, if you're dealing with a lesbian couple and one of the spouses is artificially inseminated and the child is born, the other parent has to do a legal adoption in order for it to be their child. And what I told you all last year was that at least I've had people contact me in Northern Virginia that actually make arrangements to have their child born in D.C. so they don't have to go through a legal adoption in Virginia. And they'll live in Arlington and they'll make sure their job's in the right place so that if they have some emergency and they start going into labor, they can get across the river really fast to have their child born. And this is just needed to bring our law up to speed so we can't get, because there's actually a pending lawsuit which was stayed so we can fix this. And the Attorney General's office, the other litigant is here, and they both support it. I think you all were a little uncomfortable with monkeying around with these terms without some more vetting or stewing or it being out there a little longer, and I think that's happened, and I would hope we can pass it this year because we need to do this to comply with what is the Constitution now.
Questions of Senator Servell? You have people who'd like to speak, Scott?
Chairman,
Senator McDougal.
the timeframe, whether regardless of none of this is codified now, correct?
You're talking about
Well,
on
I
the
mean,
first
like,
page?
On the first page, correct.
It's all common law, and this correctly states the common law. Except it brings it up to speed for same-sex couples so that we don't have to litigate that with the Supreme Court or the Court of Appeals.
Can I ask a question?
Senator Peters.
All right, let me go through sort of a heterosexual situation where you have a couple that's married, maybe they're no longer living together, they're no longer having sex, and a child is born, and the father can say, not my child, and can establish that, okay, and rebut the presumption that you have here. Let's say you have a same-sex couple that are together, and for whatever reason, they separate, but they don't divorce, so they're still together. Is there a scenario where one could then have a child and the other one now becomes legally obligated, even though they weren't aware of it and didn't consent to it?
It would be a rebuttable presumption.
But how would they rebut the presumption? In the first situation, you say, here's my DNA, that's not my child. How do you rebut, I mean...
You do that with DNA or the absence of a surrogacy contract.
But do both parties have to sign the surrogacy contract in order to be obligated? I mean, this to me would seem to make it, they're both obligated, even if one didn't even know about it.
I don't see that scenario happening. Maybe Joe might be able to, he's dealing with this litigation right now, and I'm sure he can address it.
Senator, the language is still in there if it's a same-sex couple. You just have to, you can rebut the presumption by proving that, let's say the non-gestational mother
Right.
in the situation, you have to rebut it by showing that you didn't consent to the artificial insemination.
Okay, how about if you didn't know about it?
Then you, by definition, there would be no consent.
I'm not sure about that when you have a rebuttable presumption. I think the burden's on you.
Well, I think if you don't know about it, you know, informed consent requires knowledge.
Senator McDougal?
Mr. Chairman.
Senator Stewart?
But isn't it much easier to get a rebuttable presumption after the fact with circumstantial evidence? I mean, you know, what in the forefront you may have thought really difficult to prove, suddenly after the fact you can gather a couple pieces of circumstantial evidence and you've got a preponderance of the evidence and you can't rebut it. I think that's what Senator Peterson's concerned about, and I share the same concern.
You may have the same concern here. This concern already exists. It's existed under the statute right now with heterosexual couples. So, for instance, let's say my wife decide to have a child through artificial insemination. We use a sperm donor, so it's not genetically related to me, okay? But then add to the hypothetical, decided that I had not consented to this, we have the child. I'll have to go out and disprove that I did not give consent, and I won't be able to rely on DNA evidence.
Fair point. All right. Senator Chafin.
So my question is, what happens when you have an individual who doesn't know about the conception of the child? They're married, but they're not living there, doesn't know about the conception of the child. That issue goes on for years, and you have years and years of SNAP benefits being paid attributable to that individual. Is it not accurate that they cannot get out from under their financial obligation to the Commonwealth?
Senator Chafin, you're going to have to, I'm going to play daft here. You're going to have to explain to me who the theys are. That
Okay,
you're dealing with.
You have a couple, a heterosexual couple, but they are not living together. A child is conceived within the rebuttable period. The spouse who is not living there doesn't know it for years and years, lives on the other West Coast, for example, and SNAP benefits are being paid all of these years, and they have been reported as the parent, that spouse on the West Coast. They don't have the ability to get out from under that, do
I
they?
thought there's no obligation to repay the SNAP benefits unless there's a child support order in place, but I could be wrong about it. I don't do a lot of those cases, but I didn't think the obligation to repay is unless child support is there. And obviously in the child support proceeding, you'd have the ability to challenge parentage at the initial outset. I don't know if DCSC can answer that question on the SNAP issue, but I'm pretty sure. I don't do a lot of those cases. I can't tell you 100%.
Any other questions? All right. All right.
The Attorney General's office is here also.
Yeah, let's hear from the Attorney General's office.
Mr. Chairman, Sam Towle, Deputy Attorney General for Civil Litigation. We support the bill. In the wake of the Obergefell and Pavin cases, the word husband in 20-158 ought read spouse under federal constitutional law at this point. Thank you.
You all have a view on the first provision? Or your view confined to the Code Commission recommendations?
Confined, sir.
Thank you.
I think Mr. Wilson wants to speak as well.
First of all, I'm Joe Wilson from the law firm of Kelly, Dry and Warren, and thank you very much for letting me address you today. And Senator, thank you for introducing this bill. I'm here, and why am I here? I represent a same-sex lesbian couple, and I'm here to speak principally to you in support of the provisions of SB 1544, then amend the provisions of the Virginia Act on the status of children of assisted conception, in particular 20-158A, Mr. Tal just spoke of that. That uses gender-specific language. The bill proposes it to change, to make it gender-neutral language, in particular, changing husband to spouse. And as Mr. Tal said, that is completely commanded and required by the Obergefell versus Hodges case, and then Smith versus Pavon, both Supreme Court decisions. Okay? A little bit of back.
And we've heard this before, so ask you to confine your comments. Senator Stewart, and I think we all understand that portion of the argument. How about your view on the first part of the bill?
Again, I'll be honest with you, that's not really my bailiwick,
Okay.
100%. But I do, from what I understand in this area, the presumptions do follow the common law, this 300-day
Okay.
period.
All right.
Okay.
Let's hear from the Family Law Coalition.
Mr. Chairman, the Family Law Coalition supports the legislation.
The whole thing?
We do.
Okay.
Mr.
All right. Senator, who's that? Senator
Peterson. Let me ask the Family Law Coalition a question. Subpart F uses the phrase cohabitation. So in other words, the rebuttable presumption says, any presumption in subsection D, which I assume is what we're talking about.
E, not F, E.
E, yes, but E starts with any presumption subsection D may be rebutted by sufficient evidence that would establish by POE the parentage of another person or the impossibility or improbability of cohabitation with the mother for a period of at least 300 days prior to the birth of the child. That to me is dealing with a heterosexual situation. I mean, would you agree with me? Am I crazy here?
I think you could read it that way, but
I don't see any other way to read it.
But I think that's just one example. It's not exclusive.
But we're codifying the whole common law, not only the law for same-sex couples. We're codifying the law also for heterosexual, common law for heterosexual couples also. This states the common law.
Well, I understand that, Scott, but I mean, it seems like we're changing the common law, but at the same time, we're affirming the common law. I mean, these are heteronormative concepts. What you have in subpart E, you'll agree with me. I mean, am I crazy?
Is that a rhetorical question?
I guess what I'm saying is, well, never mind. What am I?
I'm not sure whether the Supreme Court allows us to make that distinction or not.
I guess to go back to the original point that I made to the gentleman, which was you're putting into law, the rebutting of the presumption really only applies to heterosexual couples. That's what I'm saying. When you talk about cohabitation, you're clearly talking about the two parties having a sexual act that produced a child, and if they're not cohabitating, then that's unlikely to have happened.
I think he's correct.
All right.
I'm not saying the bill's bad or good. I'm just saying let's be.
No, I got it. I know.
All right. So the bill is before us. I mean, we've kind of beaten these issues to death.
I could just say that, I mean, if the committee has a level of discomfort with that first part, could strike that, bring that as a standalone bill next year, and try to limit it to avoiding the adoption issue or something, if there might be a tighter way to draft it. But I think there's consensus on the second, everything after page 1, it sounds like.
All right. I haven't heard a motion to strike anything.
Okay.
All right, the bill is before us.
I would move to strike lines 49 to 51. I just think if it's a common law, it's already there, but you're going in two different directions.
I think it would actually be to strike 13 through 51.
Oh.
13.
The whole first provision, okay.
Yeah, I don't think that code section is
All right, that's
necessary
fine.
if you're going to strike that.
All right, I'd move to strike that part then.
All right, is there a second? It's been moved and seconded. All in favor of that amendment signify by saying aye. All opposed? That amendment is made. The bill is before us. It's been moved and seconded. The bill be reported. Clerk will open the roll. Dick, you voting, Norman?
Ayes 7, noes 8.
I was going to say, did you want to be?
Okay. Okay.
pretty good batting average.
Yeah, not bad. Thank you.
Congratulations. All right, next, we have members of the committee. Senator Stewart, I think you've got two bills that ought to be pretty quick. You're welcome to do either one.
Yeah. Oh, but if you don't live together.
Yeah, you're right. That's the common law. Leave it alone.
Senate Bill 1179.
Thank you, Mr. Chairman, members of the committee. I've got Senate Bill 1179, which simply clarifies for concealed carry permits that if a member of the armed forces is stationed outside of the Commonwealth but is domiciled in Virginia, then they're eligible to obtain that concealed carry permit. We had a difficulty in Stafford, and I think rightfully so, because the statute is unclear, and now I think it makes it perfectly clear.
And the difficulty was, member of the military was in Florida.
Correct.
Florida wouldn't issue it because he was supposedly domiciled in Virginia. Virginia wouldn't issue it because he was stationed in Florida.
Correct.
All right. Anybody have any opposition to this bill? You aware of any opposition, Senator Stewart?
No one's come to me,
You want
Mr.
to
Chairman.
make a motion?
Move bill be
Been
reported.
moved and second, the bill be reported. Any discussion? All in favor? Let's open the roll.
It's pretty tricky. I know you could vote from here.
Ayes 13, no zero.
And I know that there were some people here who wanted to speak, but it was on a roll. I think that was consistent with your position. Senator Stewart, next, 1201.
Mr. Chairman, Senate Bill 1201, it essentially allows a juvenile court judge, in the event that a juvenile court judge in one jurisdiction takes a matter under advisement, it allows them to transfer that case to another juvenile court in a different jurisdiction to see that through and to ultimately make a decision if that's what needs to be done. Currently, they can be transferred, but only after an adjudication has been made.
Okay.
And this bill actually was something that was vetted and is a recommendation of the Committee on District Courts.
All right, are you aware of any opposition to the bill?
No one's come to me, Mr. Chairman.
Kristen, this bill's in good shape, right? All right. Is there a motion on the bill? All right, it's motion properly seconded to report the bill. Roll is open.
Ayes 13, no zero.
All right, Senator Stewart, we inadvertently reported 1179. It should have been reported and re-referred to the Committee on Finance. Is there a motion to reconsider the vote by which we reported? It's been moved and seconded. All in favor of reconsidering the vote signify by saying aye.
Aye.
All opposed. Bill is back before us. Senator
Move be
Stewart,
reported and re-referred to Senate Finance.
is there a second? All right, the roll is open.
And, Mr. Chairman,
Ayes 15, no zero.
Senate Bill 1207, I would just ask that be passed by for the day. We continue to work on that bill.
All right, without objection, 1207 will go by for the day.
Thank you, Mr. Chairman.
Sure. Next, we have Senator Peak, 1123.
Mr. Chairman, members of the committee, Senate Bill 1123, and actually we go back to Senator Howell's bill. This also deals with 18-2-260. I'll tell you, we're adding telephone threats. So it's under C, telephone or wireless threats to this. I see some, I gotta tell you, I see a little inconsistency under one. You know, only under A1, you do it in writing or electronically, it's a class 5 felony. Under my C, it's a 6. I'm not quite sure why we do that. And then under Senator Howell's, under B, that's still a class 1 misdemeanor. This came to us from the Appomattox Commonwealth's Attorney's Office. They had someone who telephoned in a threat to that business to kill that person and their family. He had to shut down the business, go to his home to protect his family. And under the according to the Appomattox Commonwealth's attorney,
So this would
18.2,
apply to
it just-
somebody who says, I'm going to blow up your business, or?
or threatens your family member. It's really telephone threats, and he adds the other part about the business so you can get restitution. And so the other part is just a restitution. When somebody calls you, threatens your family, that they're gonna kill them, you gotta shut down your business to go see what's going on to allow them to get restitution for that.
Right.
It's, but it's also it just adds telephone. I don't know why telephone was not included when you have the, not only communicate in writing or other, electronically transmitted communication.
So this closes a loophole,
we think it
eliminates
closes-
what you believe is an inadvertent omission?
That is correct, and based
So
on what they've
a couple
told
of
me.
things. First of all, I think there was some discussion about the restitution provision.
Yeah.
And some feeling that courts can already order restitution, or there may be a civil cause of action available. Do you have any objection to striking that restitution
I
paragraph?
understand that as well. It seems to me they could do the restitution, so.
All right, so you moved it, all right.
Well, Senator McDougal likes to kill a lot of my bills. I'll let him move it.
All right, there's a motion properly seconded to strike paragraph D. All in favor signify by saying aye. All opposed? And I think, Kristen, further technical amendment, add, I guess, that last paragraph, 37 through 38, make that subdivision D.
Yes, sir.
All right, Senator Peak moves, Senator McDougal seconds. That technical amendment, all in favor signify by saying aye. Aye. All opposed? All right, the bill is before us. If reported, it needs to go to the Committee on Finance.
Mr. Chair.
Senator Peterson.
And this is a question for Senator Peake. I can only imagine the reason why we didn't put in telephone threat is that all the other threats are in writing. So there's, when something's in writing, there's a little bit more concreteness to it than saying over the phone, I'm gonna kill you, or you're a big jerk, or, I mean, how do you respond to that, a verbal statement is of slightly lighter weight, and maybe that's why it wasn't included in the original statute?
I do not know why, but they say it to you orally. But if you know who it is, and now with today's phones, their phone number comes up, it identifies them, and that could be. And I would have to, I would entertain an amendment to make it a Class 1 misdemeanor.
I'd love to make that amendment.
Yeah.
I'll make that amendment.
I'm not into, yeah.
Been
Class-
moved
Yes.
and seconded to turn this into a Class 1 misdemeanor.
Chairman, so just so I understand, so if you call somebody and say, I'm gonna threaten to kill or do bodily injury to their family member, not the person individually, then it's a Class 1 misdemeanor. So is it true if I call and somebody calls and threatens to kill me and my family member, is it two separate offenses?
No, it's regarding that person or any family
It's under
member.
420, so he's got.
It's always been an anomaly of the law. So if I write you a
Or
letter
any family
and threaten you, it's a Class 6 felony or Class 5 felony.
Yeah.
If I call you.
Mr. Chairman.
Was that under a
Hang on,
different
time out.
statute? Is that
It's a
one that
piece
you
of
just, Appomattox was not aware of? Well, let me,
You may have been unhappy with the misdemeanor. What's
RDA?
and then that could have been.
Mike, I'm sorry, I can't hear you.
I'm sorry, I was just telling Senator Peake, under 18.2-427, which is existing law, it's been around forever. If I use profane, threatening, indecent language over the phone, or threaten any illegal or immoral act, it is already a Class 1 misdemeanor. I've been prosecutor for 35 years. It's always baffled me that if I write you a letter from across the country, and it's a felony. If I call you on the phone, which is obviously a more imminent risk, it is a Class 1 misdemeanor. If I say it to your face, it's nothing. But that's one of those anomalies that just always seem to exist.
Life is full of anomalies.
And Mr. Chairman, I'm not sure if my constituent was aware of 427. He didn't mention 427 and what we were talking about. Could I move that this go by for the day?
So moved.
Do we have time, or we have another meeting?
Yeah, we've got another meeting.
Yeah.
We're not going to take up a hearing on this will, yeah, maybe that's a better suggestion.
Well, go by. I didn't hear it. Pass it by indefinitely.
Well, is to come back next year.
That might be. Or somebody may come back next year. We'll see. It is an election year, but
Mr. Chairman, I think if Senator Peake talks to his constituent and provides that other code section and thinks we missed something, then we can move to reconsider it on Wednesday.
Yeah, let's, Senator McDougal moves that the bill go by, or that bill be passed by indefinitely. All in favor, signify, well, let's open the roll. It's still within the breast of the committee.
Ayes 12, noes 3.
All right. Senator Sasslaw, you have a bill or two that, one that you want to take up? All right. Senate Bill 1164, you can do it from there. This is not a new bill.
No, it's the, Mr. Chairman and members of the committee, it's the universal background check bill with, the usual exemptions, with family and legal transfers. But other than that, it's requires a background check for any firearm transfer and requires the Department of State Police to establish a process for transfers of firearms to obtain a check from a licensed firearm dealer. And like I said, it lists all the usual exemptions that we have in there. And if they don't get the background check, it's a Class 1 misdemeanor.
All right. And this is, I believe,
if you remember, I had a bill.
Identical.
Yeah, it was similar, except
Similar
the other
to-
bill also raised the buying age, if you remember, to 21.
Right.
This is just the background checks.
And this is, there's nothing new in this
Right.
concept. We're very familiar with it, unless you have any folks who you brought here who you feel
Not specifically.
need to testify.
If somebody wants to testify for it or against it, but.
We'll hear from you.
Good afternoon, almost. My name's Christine Payne. I'm a resident of James City County, a member of the American Nurses Association in our Virginia chapter. For decades, my professional organization, which represents the largest health provider group, has demanded that lawmakers pass common sense gun legislation to curb gun violence and enhance our public safety. I share their position. I don't believe any one of our new proposed legislations would eradicate gun violence from our streets. We can all attest to that. But we do need to move forward in a way that brings us closer to eradicating gun violence. We can do this incrementally. We can do this with common sense legislation. I believe this is one of those pieces of legislation we can all agree upon. I support SB 1164. Thank you.
Thank you for being here and sharing your views. Yes, sir.
Mr. Chairman, Andrew Goddard, Virginia Center for Public Safety. You know my position on background checks. I'd just like to just say one thing, and that is that please remember that a gun that's been previously owned and a gun that has been purchased brand new from a dealer are just as lethal as each other. Therefore, when they're transferred to someone who may not be legally allowed to have them, we should be intervening with a background check. Thank you.
Thank you, Mr. Goddard.
Good afternoon, Chairman, members of the committee. My name is Kelly Roscom. I'm the legal director of the Educational Fund to Stop Gun Violence. We very strongly support this bill. It does not prevent law-abiding citizens from purchasing firearms. It merely prevents those who should not be able to procure one from doing so. It also prevents a lot of firearms from entering the illegal market, which I know we're all concerned about. Thank you very much.
Thank you.
Good morning. I'm Joanne Sweeney. I'm a concerned citizen from Chesterfield County. Excuse me, I have a little bit of a cold. And I strongly support this bill.
Thank you.
Mr. Chairman, members of the committee, Nikki Zamosny, Assistant Secretary of Public Safety and Homeland Security, and for all the reasons already mentioned, we support the bill.
Thank you.
Mr. Chairman, members of the committee, Felicia Preissner with the Virginia Catholic Conference, and the Virginia Catholic Conference also supports this bill.
Thank you. All right, we'll hear from those in opposition to this.
Mr. Chairman, ladies and gentlemen, Bob Sadler, Virginia Citizens Defense League, and you already know our position on this bill, but one of our members came all the way from Roanoke only to have to leave over a health issue, so if I could raise his concerns. His name is David Hicks. He is a retired federal investigator in good standing with a top secret clearance, and he regularly runs into problems because one of the first people prosecuted under, I believe it's the Patriot Act, was an Australian named David Hicks. And David is just one in a litany of false positives that bog this system down, and expanding it to private sales is only going to be an unmitigated disaster. Thank you.
All right, thank you. Next.
Mr. Chairman, members of the board, committee, my name is Patricia Webb. I'm with Virginia Citizens Defense League. I'm also a licensed firearms dealer, and I can tell you that 99% of the background checks that have come back as denied have been overturned on appeal. There's a high rate of false denials, and this bill is not solving any problems. It will not prevent criminals from getting firearms, so we strongly oppose this bill.
Thank you.
Thank you. My name is James Maitland. I'm 4-H instructor in Goochland County. As I understand it, a transfer would not allow us to educate the youth in how to safely handle a firearm because they wouldn't have not gone through a background check every time we lent them a gun, as well as most guns that are used in a crime or stolen. I'm also work for a firearms dealer, and thank you for hearing my case.
Thank you very much.
Mr. Chairman, Chris Kopacki, State Director of the National Rifle Association, and for the same reasons we stated last week, we oppose.
All right, thank you. All right, the bill is before us.
I move to report.
Senator Sasslaw moves. Second. It's properly seconded that the bill be reported. The roll is open.
Ayes 6, nays 9.
All right, the bill fails to report. Senator Stewart, can you take the chair? I've got, I think, 3 quick bills.
Where are we? I'm over here.
Senate Bill.
You want to stay here?
1619.
Senate Bill 1619. Who is that? Oh. Mr. Chairman, sorry. Senate Bill 1619. 1620? 1620.
All right, 1620 is protective order bill. What this does is it does a couple of things. First of all, it changes home of any protected party to any land, buildings, or premises when such entrance is prohibited by a provision of the protective order, which basically deals with the limited situation. Do I have a substitute? No? Okay. Deals with a limited situation in which the subject of the protective order may have a lease or right to occupy a building on the property, maybe an apartment. This gives the court the ability to carve out that in the protective order. It doesn't take away the discretion of the court or the ability to protect the intended victim. Also, it provides that that's all that this one does. Okay. Pretty simple.
Questions of the patron? Anyone who'd like, well, let me try it this way first. Is there any opposition to this? There's a motion to report and re-refer to Senate Finance, and second by Senator Edwards. Clerk, please call the roll.
Ayes 15, no 0.
And next bill is 1429. I hope this is similarly simple. This is a bill that is brought on behalf of a number of DSS attorneys across Virginia deals with child protective orders in cases of abuse and neglect. There really are two options. You can get a removal order or a child protective order. Under removal orders, medical records can be submitted 24 hours in advance of the hearing and admissible. But for whatever reason, there's not a similar provision that allows the submission of medical records for the child protective order. This simply, 1429 is not?
Yeah. It's a good bill. You would like.
Okay.
Mr. Chair,
Senator Dees.
my question is, do you always have 24 hours?
I don't know, but this simply provides the same procedure in cases involving the removal orders. It gives more latitude and more ability to get those medical records considered because of the short time frame. You may not be able to get the medical record custodian there. If you don't have the 24 hours, you're going to have the same problem in the removal cases, and they're going to have to get the medical records in some fashion or another. This simply is a tool that's available for those other cases, and there seems to be no rational reason why it wasn't made available for these child protective order cases.
That is not a change in the law. That's existing law with the 24 hours. They just use 24.
It doesn't change that. It just adds the child
preliminary
protective orders to the same procedure.
Is there any opposition to this
I
one?
move to report.
No opposition. Motion properly seconded to report the bill. Clerk, please call the roll.
Ayes 13, noes 2.
No, I've struck, Mr.
You want to try this? Strike the roll, please.
I move to reconsider.
I think we can strike it and do it again.
All right.
Can you? There's a motion properly seconded to report the bill. Clerk, please call the roll.
Ayes 15, no 0.
How many times can we reconsider a vote? All right. We're going to unwind a second time 1179, Senator Stewart's bill, which turns out did not need to go to finance. Is there a motion to reconsider the vote by which we reconsidered the vote? All right, it's been moved and seconded to reconsider the vote by which this was reported and re-referred to finance. All in favor signify by saying aye. Aye. All opposed. The bill is back before us. Is there a motion to report?
So moved.
It's been moved and seconded. The bill be reported. The roll is open. All right, that
Ayes
bill
15, no 0.
is reported. Next, we have Senator Howell. You have 1078.
Mr. Chairman, I have an amendment in the nature of a substitute for 1078.
All right, Senator Howell moves. Senator Edwards seconds the adoption of the substitute. All in favor signify by saying aye.
Aye.
All opposed. Substitutes before us.
Mr. Chairman, just to refresh everybody's memory, we were talking about this at our last meeting. It deals with stalking, permanent protective orders for stalking, and it would treat them the same way as we treat permanent protective orders for family abuse. It was pointed out that the bill had additional language dealing with certification and so on, which actually I didn't particularly care about or want. So what we've done is strip the bill all the way down just so that the permanent protective order would be including the stalking protective order as well as family abuse.
And you're happy and comfortable with this version
Yes,
of the bill?
I am, yes.
And it's not going to, you're going to resist amendments?
Yes.
To expand it?
I am.
Okay. All right. You have anybody here to speak in favor Governor's office likes it. Anybody opposed to this bill in its narrow, more narrowed form? All right, step right up. You know what the substitute does, right? Okay.
I was subject to a 2-year protective order by a neighbor. He made false claims against me after I asked for a peaceful resolution to an ongoing drainage blockage issue that was flooding my house. He was able to get an order that was based off lies, cost me 7 months of not being able to work in the industry. The final order was dismissed after prejudice. My family went through a tremendous amount of stress, several court appearances, over $6,000 in legal fees. The judge initially issues these orders based off just one side of testimony and are reluctant to remove the order. As my general district judge stated, we're going to err on the side of safety. After my neighbor was not able to demonstrate a threat or the presence of a firearm or weapon as stated in his order. There was no penalty for my neighbor to make these false claims. If this bill was passed, I would not have been able to defend my household during the 7 months. I strongly oppose this bill.
All right, thank you. Anybody else in opposition? All right, you all, do you feel compelled to be heard?
Chairman, Committee, Patricia Webb, Virginia Citizens Defense League. I would like to point out that the threshold for these protective orders is often relatively low, and this can apply to a protective order against somebody that lives maybe 30, 50 miles away. It would eliminate their ability to defend themselves in their own home. We oppose this bill.
All right, thank you. All right, bill is before us. And it needs to go.
It needs to
It
go to
does?
finance.
It does?
It
Okay.
needs to go to finance,
It does
sadly.
need to go to finance. All right, is that your motion?
Yes.
Senator Howell moves, Senator Stewart seconds. Bill be reported and re-referred to the Committee on Finance. All right, the bill reports, and it's going to finance.
Thank you.
All right. And Senator Edwards, 1288. And I think that is the last bill today. Oh, we can take up your body cam bill. Do we have time to? $12.88.
Yeah, we have an amendment.
All right, does this amendment take care of the situation where somebody is in jail for failure to pay child support?
No.
It does not?
Well, it's.
Okay.
It's, want to read the amendment, or do you have the amendment, Kristen?
Mr. Chairman, I have 3 amendments. On line 42, after a party's, insert current, so it would read a party's current incarceration. The same amendment would be made on line 109, and then a delayed effective date for July 1, 2021 would be added to the end of the bill.
And these are technical amendments?
They are technical.
Okay, so it only applies to current incarceration? All right, Senator Edwards moves, Senator Stewart seconds those amendments. All in favor of those amendments signify by saying aye. Aye. All opposed? All right, those amendments are adopted.
Mr. Chairman, what this bill does, first of all, it's required by federal law. Federal law, I think in 2021, requires that states no longer treat incarceration as voluntary unemployment, which is what the Supreme Court of Virginia says it is, when establishing or modifying a child support order. So this change is necessary under federal law and to retain federal funding.
All right, so my question before was not just a joke. Take somebody who is in jail because they are not paying their child support. Under this bill, doesn't that mean that they are not voluntarily unemployed or underemployed and can avoid child support for the time that they're in jail for
That's-
not paying their child support.
That's based upon holding someone in contempt of court, is my understanding. Is that right?
And that's not covered by this?
Mr. Chairman, members of the committee, Craig Bersham, Deputy Commissioner for the Department of Social Services. Senator Edwards is correct. That would be civil contempt. It's not a criminal incarceration. So this does not apply to civil contempt.
Steve, do you agree with that?
I'm sorry, I don't, Mr. Chairman. Incarceration is incarceration. Period.
I think that's right. It doesn't say civil.
Well, there's a difference between civil and criminal. I think this
Well,
has to do with
and-
criminal. But
I mean, isn't that criminal contempt anyway?
There's different types of contempt, but I
Can
think.
it be criminal contempt?
Sure. But we don't even need to go there. You're either incarcerated
Right,
or
well-
you're not. It doesn't
Yeah.
matter the basis.
Mr. Chairman, that's, I think what Mr. Benjamin said is the point. It doesn't really matter how you got there. You're incarcerated.
yeah,
A potential solution for this would be after the word incarceration, comma, other than for failure to pay such support, comma.
So
You okay with that?
I think so.
All right, Senator Edwards moves, Senator McDougal seconds that amendment. All in favor signify by saying aye. Aye. All opposed, that amendment's made. Any objection to the bill? Anybody opposed to the bill in the room as amended? Family Law Council, Coalition, y'all don't like it?
Well, yeah.
Wow.
With respect to the senator, this was a very difficult discussion for us, primarily because the bill does set aside a very robust and longstanding Virginia precedent that incarceration is not a proper grounds for a modification. And many of us have had cases where we represented incarcerated individuals and filed petitions to reduce, and it's been thrown out on a motion to strike. I think I have to cede the point that Mr. Bersham makes about the federal regs, but I echo the concern about the word incarceration. And I think you could be in a situation where a person is incarcerated for contempt purposes, maybe not for failure to pay support, but for failure to comply with another portion of the court order, loses their job, and then, you know, has this as a defense. And that's not a situation that we would want to see.
Now, and I don't think you ought to feel too bad about your position. I mean, I have great sympathy for people who, for whom incarceration provides an impediment to employment in the future, but this is pitting the incarcerated person against their children and their spouses. And, you know, I just am not sure that we ought to be adopting a policy. I don't, and maybe that policy is going to be foisted upon us, but making that choice against children and spouses.
Mr. Chairman,
Senator McDougal.
do you read the way this is currently drafted, that a party's incarceration shall not be deemed? Do you read that as if you're incarcerated and then you lose your, let's say you're incarcerated for DUI for a week and your job terminates you, but you could be working, do you read this to mean that that individual could then say, I wasn't voluntarily unemployed?
I think that's our concern, that if incarceration causes the loss of the job and an inability to pay, that you've got a defense. Whereas under existing Virginia law, you don't, because it was your own misfeasance or malfeasance that led to you losing the job.
I agree.
All right. Senator Edwards.
It's emotionally satisfying to say if a person is locked up because they're voluntary criminal act, that therefore they're not voluntarily unemployed. But the fact is, they're locked up and they are making 30 cents an hour.
You want to make a motion on your bill? I mean,
I moved to report because we're required to do this under federal law. The Division of Child Support Enforcement, which is requesting the bill,
Do you have a
rarely
second?
collects support from incarcerated
To
parents.
report? Okay. All right, it's been moved and seconded that the bill be reported. Roll is open.
Ayes 3, noes 11, abstentions 1.
All right. Anybody else have a bill that they have a witness here for, or somebody who's been long-suffering and sat through this whole committee waiting to testify to? I think we only have 2 bills left. Kristen, how are we doing bill-wise? 1033. All right, without objection, 1033 and 1621 will go by for the day. I'm sorry, somebody, which bill was it? It's just going to take longer than we have, and I'm sorry. All right, committee will rise.